then on my right, I have the learned friend here, Advocate Futuli, who is a board member and also who is the chairperson of the Legal and Governance Committee, who will be leading us today. So my job is easy, but he's the one who it is show today. So I don't know between me and him who is Mandanga, but then you can then decide. But nevertheless, that's Advocate Fiduli. Next to him, we have our Deputy Chairperson, the Deputy Chairperson of the Pan South African Language Board, Professor Napiadi Zwalo. I call him E2000 because Mina I'm a 1K. Yeah, now he is a 2K. I don't know whether he likes it or not. And sometimes I call him DC Prof, the young professor. And we are proud of him, and especially during the youth month. Next to him, we have another board member, Dr. Vulindlela Mona, our veteran. He's not a 2K. Me and him, probably we are the 1Ks. Dr. Mona, who's also a board member and also the committee member of the Legal and Governance Committee. And then next to him, the lovely lady in pink, we have Dr. Mudau, Dr. Mpho Mudau. I call her the parliamentarian because she's full-time in parliament, but she is a board member here at Pan South and also the member of the LGC, the Legal and Governance Committee. And then that's her waving. And then last but not least that I'm introducing here, he's not a board member, please, but we allowed him to sit next to us. He's the, it's Mr. Nkuna. All the linguistic human rights issues and matters at Pan South. He is based in the office, at the Pan South office. Those of you who may not have seen him in person, that is the man who is responsible for all the linguistic rights issues and matters. That is Mr. Jeffrey Nkuna. Mr. Nkuna, you want to wave also then. Then let me then acknowledge all the people that are here, but I may not say the name. Let me acknowledge Mr. Lawrence, who is here. I call him my Iblesalang. Don't be jealous. No muntu nali Iblesalang. Mr. Barenos, but Mr. Barenos know that Mr. Lawrence is my blesser. That is fine. And we've accepted, and his wife has already accepted that. Mr. Lawrence, we acknowledge you. And then I wish to acknowledge from the Legal Practitioners Association, Professor Khalakhala. When you read it, it's like Rala Rala, but when you read it, it's Khalakhala, as in Afrikaans or Mesikosa. We wish to acknowledge he's a forensic linguistics expert. It is a new field in the country, so if you want to know more about forensic linguistics, he's the person who is fighting for our rights in that regard. And he's the one who popularized forensic linguistics in the country. Otherwise, it was only recognized elsewhere. We do acknowledge. And also he is the DVC of academic at the University of Western Cape. And let me then also acknowledge the people from NADEL. I won't call the acronym, I'll just say the acronyms and not say the names. They'll introduce themselves later. And then we also have colleagues from NBCSA. Let me also then acknowledge the LPC, the people that are here. And just before I then step down from what I have is that, you know, when we gather here, we are not in the court of law. It is a matter of mediation in this public hearing. It's mediation and conciliation. It's the negotiations. We want to say that, you know, let's find each other with regards to the language rights. So where as PenSouth we are not doing it correctly and so on. So we are here to offer each other constructive criticism because we all love our beloved country, South Africa, and we all love our languages. And also as the Pan South African Language Board, we want to promote all the 12 official languages of the country. So when one language is used, as if we're in the UK, you can imagine if we're in the UK, they say that the only language that will be used in the UK is isiZulu. What will happen to the Queen's language? Or if you are in Germany or in China, they decide to use Xitsonga or Tshivenda, what will happen? So we have 12 official languages in the country. So we are here so that we negotiate. So whoever is responsible or is an official in their respective space, let us find each other and then make sure that we address that. So the two issues, as an academic, they always say that when we say that let's make education available in all our official languages and let our children learn in their languages, people think that we say we must lower our standards. Nobody has ever said that because the content is still the same. It's just a matter of the language that's changed. But there is that myth and there is that fallacy that when we use our languages, then you are now lowering the standards. So we want to correct that. We are definitely not lowering the standards. And then the last part is that we have 9 provinces. And then in these 9 provinces, we don't speak all 12 official languages at a go. Probably here in Gauteng, the chances yes, but it is only in Gauteng. But in the Western Cape and Eastern Cape, the dominant language will have your Afrikaans and isiXhosa. The chances of you getting Mutonga and Tshivenda in the Eastern Cape and Western Cape are slim. So then that is the practicality of it. Then you will use the language that is there. So if you go to Polokwane, Limpopo, the languages that we say we want to advocate, you will then use your Tshivenda, Sepedi, Xitsonga, because the chances of you getting isiZulu or isiXhosa are slim. When you are in Northwest, you will then use the dominant language, your English Afrikaans, Setswana. When you are in the Free State, you will use your Sesotho and so on. Mpumalanga, where the sun rises, you will then use your isiNdebele, Siswati, and so on. So by the same token here as the board, we want to advocate for them. That is why we say that we do not expect any entity, any organization to use all 12 official languages at a go, but we're just saying that, let's find each other and then use them. With those few words, I wish to thank all of you for availing yourself, you who are here in this space and those who are attending in the virtual space. And then let me take this opportunity then and give and hand over to the chairperson of the Legal and Governance Committee, Advocate Fituli. Thank you. Advocate, over to you.
Thank you very much. Yes. Thank you very much, Chair. Thank you for the introductions. Let me appreciate the opportunity given to me by the board as well as the Legal and Governance Committee to chair the proceedings today. And I wish to indicate upfront that these proceedings are triggered by a complaint that was received by PenSouth. And following that complaint, there was an advisory issued to the LPC with regard to language policy. And now we are now continuing the investigation. So we've called LPC to come and appear as per the important provisions to submit any information on any evidence with regards to their language policy. So mine today really is to guide the proceedings and to make sure that we get as much information as possible for us to be able to fulfill our constitutional duties as PenSouth. I want to give an opportunity to Mr. Nkuna just to outline the important provisions. I think we all appreciate that language rights are founded in the founding provisions of the Constitution. And the very same Constitution then founds PENSAP. And it's quite specific on the mandates of PENSAP with regard to languages. So I want to give to you, Mr. Nkuna, just to give an outline in terms of the framework, so that all of us, when we start the proceedings, we are confined to the mandate that is given to PENSAP, so that all of us can support PENSAP to be able to achieve its mandate. Over to you, Mr. Nkuna.
Thank you, Chairperson. Should I do it from here or there? Fine, thank you very much. Well, my name is Jeffrey Nkuna. I've been introduced. Let me take this opportunity to welcome all the participants and in particular the people who are in the public platform. I was just requested by the chairperson that this is a public interest matter. So it's crucial and critical that at least the public is aware of the proceedings. We must not take it for granted that the public understand what is the constitutional and legislative mandate of the South African Language Board. I'll just make few remarks and I'll be quoting from the Constitution because we cannot just assume. People are aware of some of the provisions of the Constitution, but our ordinary people, the most marginalized, are most probably ignorant because I deal with complaints on a daily basis. So it's very important that whatever I'm going to say, it comes from the Constitution, and that's not my opinion. Firstly, Section 6 of the Constitution officially says the official languages of the Republic are Sepedi, Sesotho, Setswana, Seswati, Tshivenda, Xitsonga, Afrikaans, English, isiNdebele, isiXhosa, and isiZulu. And currently, one of the 12 official languages is the South African Sign Languages. What is also important in the provisions of the Constitution is the fact that there is a provision in our Constitution, in Chapter 1 of the Constitution, which re-emphasizes the importance of these languages, recognizing the historically diminished use and the status of the indigenous languages of our people. The state must take practical and positive measures to elevate the status and advance the use of those languages. Underline that. Positive steps are expected from the state, including the organs of the state. The Constitution further says, Pan-South African Language Board, established by the national legislation, must promote and create conditions for the development and the use of all official languages. So that is what is provided for in the Constitution. However, it's also important to note that there is an enabling act which actually gives specific powers to Pan-South African Language Board. I'll make few reference to what provisions which are actually relevant to our proceedings. Section 8 of the Pan-South African Language Act provides that the board, in addition to any powers and functions conferred or assigned to it by law, may, having regard to the constitutional provisions, what I've already articulated, to the constitutional provisions and principles of dealing directly or indirectly with language matters in general, as to subsection 3.9 of the Constitution, to monitor the observance of constitutional provisions regarding the use of the language. That is a provision. Section 6, which actually is what makes our colleagues to be here, to be part of these proceedings, is Section 8, subsection 6, which provides that the board the board may summon any person to give evidence before it or to produce any official document or such other information or object as may be necessary for the performance of the board's function. So we are actually performing our function in this process. And finally, which I think is also relevant to the project, the board, that is the Act, Section 9 says, the board shall strive to promote close cooperation between itself and the organs of the state, and or any person, body or person, or any institutions involved in the development of the language. And in actual fact, there's also a provision that all state organs are required by law to cooperate with the board. So I have tried to outline the legislative and the constitutional mandate for the benefit, because here, of course, most people are aware of that. There are no technicalities. The provisions are very clear, but I think they're very relevant to our public outside, in particular because the issue of public awareness, insofar as the issue of languages, has taken backseat in our country. So I hope that by saying this, we are actually indicating the importance of this process. Thank you very much, Chairperson, for the opportunity.
Thank you for that outline, Mr. Nkuna. So I want to explain as well that because this is a summon to appear, this is not a court of law or a quasi-tribunal, but it's a process to solicit information through a summon. So I'm going to expect that we don't come with legal technicalities, but we try to assist the board in terms of providing information. Everybody will be given an opportunity to be able to present the information to the board so that we are able to deal with these issues properly. As I indicated earlier on, that this is a Section 11 process. And if you look at the heading of Section 11, it talks about mediation, conciliation. There's a clear process outlined by the legislation. And I think PENSALP has followed that process. Until we are here now, we've issued a summon so that we can get more information before we can act in terms of Section 5, which now requires us now to have to make a determination, resolve the conflict, and make a determination. Now, as I indicated, the rules of engagement are very simple. We just have to make sure that we listen to each other. Everybody is going to have an opportunity to present. Let us give them an opportunity. Let us not interject. Let us not make gestures that may not be, or unwanted gestures. Let us make sure that we work together. And for those who will be providing information for the purpose of the summon, we will administer oath or affirmation. And I hope that is acceptable to all those who are going to be presenting. Of course, we do have members of voluntary association within the legal profession. We're also going to get information from them with regard to this particular matter. But also we've got experts that are here that are also going to present and provide information. So at the end of it, then we'll have we'll close from there. So in terms of the program, Chair, I think that I've started with the matter, and then the next item on the agenda then. Yes. Yes, so I'm going then to invite the complainant in this matter so that we can commence with the proceedings. I don't have an attendant information. Okay. Mr. Nkuna?
Chairperson, I just wanted, maybe you might have missed the issue of the allocation of time to presenters. And there's no cross-examination in the process. They've already articulated to re-emphasize that.
Yes, no, let me re-emphasize, you are correct, Mr. Nkuna. This is not a court of law or a quasi-judicial tribunal. We're just here to get information. We're not going to cross-examine anybody else. We just want to get information. The complainant is going to be given an opportunity to present for an hour without interruption. And then the respondent, the Legal Practice Council, will be required then to present for an hour. And then other experts and professional bodies and stakeholders will then be given 30 minutes to present. I trust that is in order. Mr. Lawrence,
Thank you.
can you hear me?
Okay.
Yes. Let me then introduce you then and indicate that you are the complainant in this matter, and you will be giving information with regards to your complaint. But before you start, I want to at least put you under oath, or do you want to take affirmation, or it's just up to you? Which one do you prefer?
I am always taking the affirmation, Chair.
Affirmation.
Affirmation.
All right. Let me then start that process. Do you affirm that the evidence you are going to give in these summons proceedings is the truth, the whole truth, and nothing else but the truth?
I confirm.
If so, raise your right hand and confirm.
I confirm.
Thank you. So you've been sworn in. I'm going to allow you then to proceed and present to these proceedings.
Thank you, Chair. Thank you for the privilege, the chairperson also of the board, board members, CEO, colleagues of the legal fraternity, and ladies and gentlemen. The chairperson of the board said you must first give your title. My title is Moetsa Molatu. I'm going to start with an intro. Then my introduction will be what outcome I want. I'm going to focus on the solution. Then I'm going to take you to my complaints, and then I'm going to elaborate on constitutional issues, and specifically the principle or doctrine of linguistic justice. And then I'm going to reply on some allegations of the LPC, which is in the bundle. And then I'm going to put my case as Afrikaans speaking attorney. Chair, the great Dr. Albert Luthuli in the high treason case was pushed by the prosecutor to admit that he is in favor of violence. He refused. He said, and I'm paraphrasing now, he said, I will keep knocking on the door of the white man, and I'm sure it will open. Now I'm using this intro, the knocking on the door. Now, in 2002, I was on the AGM of the Law Society of the Northern Provinces, putting a motion against the adoption of the policy by the LSSA, that's the predecessor of the LPC, that the rabies, that's our legal journal, the articles only be published in English. We lost the motion, but my one very important thing was reported in the rabies 2002, and it's public. It's in the LPC. People can go and read it. Mr. Lawrence accused the LSSA because that they do nothing for multilingualism. Today, it's 24 odd years, and I'm again here to knock on the door. What is the outcome which I seek? The language issue, as one of my icons, Dr. Neville Alexander, is not a simple issue. And my experience with the LPC is that they simplified it always, the language issue. They simplified to 7 letters to English. Now, the language issue is complex, and we require in the legal fraternity a a proper language plan. A plan which deals with the use of languages, and we must start at the lower courts. It will assist with the backlog in our courts, that on certain in the areas like isiXhosa speaking areas in KwaZulu-Natal, all over, where the accused, the magistrate, the prosecutor, all of them are isiZulu speaking. They must be able to proceed at least in their in isiZulu, and not to have a double time with interpreting to do a record. So that is so the language plan is a very important thing, and how to come to it. There should be consultations. The LPC should come in as a main actor, and as some of you know, we had that fantastic meeting with the Chief Justice Maya in Umtata on the 26th of March, which I had also the privilege of being a panelist, and she is very language sensitive. As you know, she already published a judgment in isiXhosa, in Afrikaans, in Unisa case also. So we have a person who understands the whole situation. So we need a language plan. We need a coordinating committee to initiate this. And then in regards specifically to the complaint, I will deal with later in a more practical sense, which I suggest being done. So what I require from the LPC is that they must constitutionalize the language plan, the language policy. They must South Africanize their language policy. And that is to go and read Section 6 of the Constitution, but not only Section 6, Section 9, which is about the anti-discrimination clause. And then one very important distinction which I do not hear much is, as Section 6 gives citizens of South Africa the official status to their 12 languages, but in the courts they are reduced to a interpreting right in terms of Section 35(3)(k) of the Constitution. So you're entitled to an interpreter, and this 35(3)(k) became the dominant clause, language clause in South Africa, and it comes from Europe, and there's a few organizations which had this clause. It's where it's for minorities and those people who are not official language speakers in that country, to protect their language rights. So we are all over reduced to, but unless you are an English speaker, your rights are reduced in our legal system to interpretational rights, and that is not what the Constitution says. I say from the officiality stems, there's a contents to be given to officiality, and that can be dealt with in a proper language plan. And let me pause here. Language imperialism, which happened on the in June 1976, we commemorated it 2 days ago. My people, they enforced Afrikaans upon the students to do science, maths, etc. in Afrikaans. That's language imperialism. And I've said it also in Umtata, I'm going to repeat myself here. I cannot, as a Afrikaans speaker, understand what was in the minds of those people, because just after the Anglo-Boer War, the Afrikaans-speaking community was subjected to the worst language imperialism by Lord Milner. But they didn't learn. 70 years they applied it on those South Africans. So, and just for interest sake, it's in my paper also, Ukraine. Part of this whole fight is also languages. Russia enforced Russian on the Ukrainians. 2012, Ukraine adopted the language bill act, and then they started discriminating against especially in the East, against the Russian speakers. And it's one of the causes of I mentioned also in my document that there are many other examples in the world. So we need a proper consolidated language plan. Now, to focus on the issue of linguistic justice. This is a concept which I've presented in 2018 at Rhodes University. The distinguished Professor Galagala was also there. And it's actually coming from a Belgian politician. And it says actually that we're a dominant language, and English is the dominant language in the legal sphere. Where a dominant language is present, the question is, how do you make provision to limit and to enhance the say in converted commas, the weaker languages, and that is the challenge. Now, if one looks at section 6.4 of the Constitution, 6.4 has a second sentence which says parity of esteem and equitable treatment. That is the criterion in our Constitution. It's a vague term. I haven't seen any court cases which defines it. But that says, it doesn't say all official languages are equal. Equitable treatment and parity of esteem. Now, that is what should be, and that is connected to that issue or the doctrine of linguistic justice. So how can we address, in South Africa, for instance, the use of the indigenous African languages and the methods in doing that? That will come into that limitation process to not to only go for the dominant language, but to accept and constitutionalize and bring your policy in line with the Constitution. Ladies and gentlemen, the LPC failed to constitutionalize the language policy and the predecessor. If I'm talking LPC, I'm talking about the whole 30 years, which is of the Constitution. They failed to do that. They saw Afrikaans as the enemy, and they for only English, and to get it out all over. With the practical legal training, they did it. They made the material available in English. They gave the students a chance up to 2023 to write in Afrikaans, but they trained them, the compulsory training courses. Because everyone, before you get your articleship, you must go through a training, compulsory training period, 3 weeks and 2 weeks, and there's hours also available. So that was presented in English. So how do a candidate attorney prepare himself if the material and everything is in English? Because what is the intention of a candidate attorney? He wanted to pass his admission examination to become what he dreams to be, an attorney or a notary or an actuary. I just want to pause here by stating in my complaint form, I said I concentrate as an attorney, I've not dealt with advocacy. And just whilst I'm interrupting myself, there's one was a related thought of mine. So I apologize for not telling that is on the 16th of April, 2017, South Africa got a new government gazette called the Sunday Times. In that Sunday Times, it was announced that Chief Justice Mogoeng Mogoeng recorded that decided that only English will be the language of record in the courts. Okay. So what the Chief Justice has in terms of section 85B of the Superior Courts Act, the obligation is it's a must. Publish all these directives in the Government Gazette. Now, until today, that decision was not published in the Gazette, according to my knowledge, and I may be ignorant, but until March at least, it wasn't gazetted. That's why I say the Sunday Times became the Government Gazette. So that caused an avalanche of problems in South Africa for the Afrikaans-speaking community. Myself, Professor Kgalagala, Dr. Zafira Dampurat, I think she was at that stage already a doctor, Professor Shuna, and Alon Bailey, and Annelies de Vries, we wrote an open letter in the newspaper. What we call now it was, but an open letter to you, in which we put out the whole case that that is a wrong decision. He ignored it. Chief Justice Zondo didn't do anything about it. Chief Justice Morris last year on a conference in Cape Town indicated that
you cannot disconnect Facebook.
And
you cannot spin the recording. No, you can't spin the recording.
No, I didn't say you must.
Please bring back up. Go to this connection first. Let's see. I told them to the top side charge. Perfect. They want to go. Mabella Mila, out the
on this decision. Now you come as a attorney, you come with an application, you lawyer from the chief. So you first have to ask for the. Is he going to recuse him? We are of the opinion. We were of the opinion. I'm still of the opinion he wouldn't have. So at the end of the day, it would have been rejected with a heavy cost order. Some of you may say, well, there's a Biowatts case which says if you raise constitutional issues, then you can't be, that's paragraph 42 of that judgment. 24 says if it's inappropriate. So he created a fourth sphere of government. So he's untouchable with this decision. And this created this whole chaos in the, and this, if you look at the answer chair of the LPC, they found their one big reason on this policy of that directive. That is also the foundation of their language policy. What did and perhaps they can, when they can come and tell us, what did they do to ask the Chief Justice? The principle of constitutionalism, legality requires you to comply with the Act of South Africa, and the Superior Court's Act says you must publish it in the Gazette. Why didn't you do it as yet? That's one question which I would like to answer. So, following that decision, I call it a language coup in South Africa, because I say it's a legislative and executive function which he took on himself. Now, to be fair, Chief Justice Maya, I said the same things in front of her on the 26th of March. Afterwards, she replied, she said, okay, his decision was, it was also the heads of the courts, other courts. But at the end of the day, he was a Chief Justice, he gives the directives. So, what happens with Section 6 of the Magistrates Courts Act, which says the Magistrates Court use any language of record. The Magistrates Court is a creature of statute. Only Parliament can change it. But the Superior Courts Act make provision for the heads of the judge presidents of each court to give directives to the magistrates. So I was in Brits in a busy with an Afrikaans divorce line, and I and the magistrate didn't have good, so a white lady. And when she saw my case is called, she said, "Oh, I'm now going to start to introduce the policy of Chief Justice Mogoeng. Call your client, get an interpreter. Okay, stand down, get an interpreter. Okay, I asked the lady, okay, you're married so and so in Afrikaans. You're married in community of property. It's binne gemeenskap op daai en daai datum. He translated because he's a criminal law interpreter. He said, she's married and so in communications, Your Worship. I thought that's a little bit good job, but many people in South Africa sit in jail because of interpreting mistakes, and you as lawyers know. I can just tell of one. I had a murder case in Bokeng a few years ago, where the lady, if she was standing, she could see. If she was sitting, she couldn't see. And when I cross-examined her on she said she was seated because I took the file over and I had to transcribe the previous evidence. Then she said no. She said she was with the people. She didn't say seated. Then the magistrate came in and said no. The Setswana word for that can mean both. So she got out of the corner. So language is very important. So my request is that the Chief Justice Office be also involved, because she is favorable to change to assist her. And if the LPC can assist with a committee, a language committee, to get the experts. You can't go without experts, and the experts are professors, these people here around the table, all the universities. The universities use their at this stage their vocabulary banks because it's their they have the rights on it. They don't share it. That should be shared. That the interpreters can't translate use words and create works, because our legislation, one of my other hobbies, the fact that key legislation like the Credit Act, the Children's Act, the Sexual Crimes Act, all those acts should be translated in at least the official language. And some of you may not know, even the Constitution of South Africa is not translated in all the official languages. What a shame. So, coming to this complaint, on the 13th of December, when all the lawyers, this office closed for the recess, there came a notice saying, we from next year, 2024, you will only write your examinations in English. No prior consultation with stakeholders, no other notice. I filed my complaint in January. I know the Academy for Science and Technology, Afrikaans intellectual organization, they complained, AfriForum complained, and I'm not sure who else has complained. So, and today we have this privilege of being here to hear, to give the input in this matter. Now, there are solutions which we could have put on the table. I know the argument is that it's a negligible percentage, but the first thing is when I consulted and discussed this issue with colleagues, they say on the limited demand for Afrikaans papers is they are scared because they feel they will be discriminated. I don't say it's real, it's a perception that they will, somebody will mark their papers, which is not conversant in Afrikaans. Chair, what's my time? If I can just.
Yeah, I don't think you've got much time left.
About 5 minutes, is that fine?
Yeah, perhaps you can.
Yes, I'm going to just summarize. I'm on the call now. So,
Okay.
The cost issue is not constitutionally is not a acceptable reason. I yesterday translated a very important 12-page document, legal document with ChatGPT. I read it through. There was 2 mistakes, 2 other words which was used. AI gives the opportunity, and incidentally, Chief Justice Meyer also made provision for that possibility. So costs can be limited to the then cooperation with Afrikaans institutions like academia and the universities who are still, they will be able to assist. The LPC Act makes provision for they can contract with them, and even the learning material. I had a discussion this week. If we can write in Afrikaans, we shall prepare our own notes in Afrikaans. We need not, you have not to fund it. But we say, if the Afrikaans and the other languages who request it, their papers can be translated, it will assist. Look at the matriculation results in KwaZulu-Natal, where they could write in isiZulu. They're the best province as far as I recall. So the translation of the papers should be made available at the, that's a demand. Then, in all the languages who request it. And my submission to is also that don't ask the candidate attorney just before the examination which language do you want to use. Ask him when they enroll, in which language would you prefer A to C to get your papers and your work, and use that statistics. That's objective. They're not under pressure, because at this stage the discrimination situation is against. I'm speaking now as Afrikaans speaker in my office. I teach them in Afrikaans. The contracts it's many Afrikaans documents, wills, etc. So they are prejudiced now to go and write in English. The Afrikaans, the majority of Afrikaans speaking students go to Afrikaans schools up to grade 12, and then to Afrikaans University. And the African speakers have, unfortunately, due to the disadvantages of the past, they have to change after grade 3 or 4 to English. So they are the formulations, and they don't have to adjust when they write it. But I am of the opinion, and I've spoken to Professor Galagala in the past, and Professor Dr. Pishula and Dr. They who did the researches. If the students can, for instance, in isiXhosa receive and if they want to write it that they can read it isiXhosa questions as well in English, for instance. So the LPC said in their reply, the University of the Free State case is a directive in the considerations which it took. That is where the notorious statement of Chief Justice Mogoeng said, where he said Afrikaans is unwittingly racist. He actually, after the critique which he received after that case in the Gelyke Kanse versus the University of Stellenbosch case, he actually emphasized Afrikaans as a valuable African language. So we must just take that in his favor. So we want the language, we want that the offer, notwithstanding the quantity, because it will have to grow. Again, the question papers in Afrikaans, and I promote also for the other languages, and that is what we want, and that must be part and parcel then of a bigger language plan in which the LPC constitutionalize their they are one. The LPC is one of the biggest organizations in South Africa, the strongest organizations, and if they can take charge of this issue, we can actualize the constitutional dream of multilingualism. I thank you.
Thank you very much, Mr. Lawrence. You can take your seat. At this time, I'm going to allow the members of the Legal and Governance Committee to ask questions of clarity, any comments with regard to the presentation that we've received. Members, I hand over to you to ask any question of clarity. Dr. Musala?
Thank you so much. And a very good morning to the chair of chairs, our chair of the committee, and to all the stakeholders. And once again, Mr. Lawrence, thank you so much for that presentation. I think, Chair, today's exercise is to get fact findings to clearly understand the depth of the presentation. I always say that language is very important, and language forms part of our heritage and our identity. And Section 185 of the Constitution clearly states that we need to promote and protect the rights of the cultural, religious, and linguistic communities. Now, in the presentation, Mr. Lawrence, you made a lot of emphasis with regard to the issue of the language plan, and that it is essential to have a language plan and a coordinating committee to deal with it. So I just wanted clarity in terms of having to narrow this language plan. What is it that you mean when you put that emphasis to that there needs to be a language plan and also a coordinating committee to deal with it? Because you also emphasized and indicated that the problem here is that the LPC need to simplify the language issue, and you went back to the issue of the language plan. Can you just clarify in your own elaboration and give us a picture of this language plan? Because I'm sitting here, and from my perspective, a language plan and a language committee can be interpreted from a different stand. Thank you.
Mr. Lawrence?
Thank you, Chair. It's a brilliant question. I'm just going to give headings in regard to the language plan. Firstly, one will be in regard to the courts, the localization, and of the language use. For instance, I'm going to use my own town. For instance, Brits has 3 criminal courts, lower courts. 2 should be available for the Setswana majority, where everybody is Setswana. The 3rd one, where an interpreter can be used, is allocated. So when the matters are considered, just a short directive, you check on the witnesses, everyone you allocate. So it's that's part of that. So that must start there. First, the first one which must be prioritized is the protection order courts, and where sexual offences, where they are a person who was sexually molested should not be should have say she must be able not only to give one's evidence, not listen to interpreter and inquiries about the interpretation, etc. So that is on the court. So lower courts. Then in regard to higher courts, I think there can be a what we call is a circuit court, where there are, for instance, in Tata, judges who are allocated that they hear the matters in isiXhosa and all over regional and circuit. So if it's for instance for Afrikaans, Northern Cape, overwhelming Afrikaans, now everything must be translated into English. So but that should come from the Chief Justice. That's why her office must be involved. In regard to the translation of legislation, that should also be part of the plan, that key legislation should be translated into of the official languages. You may know of my case, which I've lost about this, and I said it's discriminatory, that it is not translated. I lost the battle, but I don't think I'm going to lose the war over of the matter is not going to go away. So key legislation should be translated and available, because interpreters are guessing sometimes terms. So that is one further heading. Now, then the training issue. The university should be involved. They are a main stakeholder. A very good candidate for such a committee leader is Professor Kgalagala. I don't want to give him work, but he's so to coordinate the academy is very important, because they are working all over with terminologies, and the terminology bank should be part of that. So it's then in regard to the training materials and the use of AI in translation programs, etc., which will make things available, but it must be coordinated in a committee that it doesn't is not done in silos. For instance, the LPC should immediately consider this issue of the examinations, reconsider it, and show good faith in offering it, and invite a consultation. That is what I said in my paragraph 21, that a process of consultation start. And so this is a few things of the language plan. So it must be a coordinated thing, and there is where PANSALP, with PANSALP as a transformatory purpose, has to play a key role in this whole thing.
Thank you for that. I'm not sure if there are questions from my committee members. Okay, I see that there's no further questions, but I wanted some few clarity questions, Mr. Lawrence, because in your presentation you indicated that there was no consultation, but I think in the bundle here before me, I see a letter of consultation to the LPC. So I wanted clarity on that, whether this letter never reached stakeholders to solicit inputs, or what happened?
You referred to the 13 August 2020 notice. Yes. That is a notice for the language policy of the LPC. And somewhere in that bundle, Chair, there is a document of the, I was part of the drafters of that, the reply dated 14 September 2020. It's a input in that policy. So when they considered the policy, and it was published in November 2020, they decided only English. In the light, they also referred to this decision of the Chief Justice, which is, and they have to uphold the Constitution. That's one of the objects, purposes. So that was not in regard to the examinations. That advert was in regard to the policy, not the decision. Then the decision came suddenly about the examinations. That was no consultation, as far as I know of.
Okay, because I would have thought that the call for comment on the draft language policy would mean that the work of the LPC will be done in the proposed language. That means that examination complaints will be handled mainly in that particular language. Is that not your understanding of this notice?
I gave my input in that regard in that other document. We didn't anticipate at that stage that they're going to take language rights away. So there was no anticipation, and they actually continued for 3 years to provide the service. So there was no anticipation that they will that they will change that.
Okay. Thank you very much. Okay, I see that committee members are covered. Mr. Nkuna, you covered. Thank you very much. Okay, if there's no further comments of clarity or comments, then we'll move on to the next presenter. Our CEO, Dr. Sishoka. Yes, please, please, if you could present.
Good morning, ladies and gentlemen, and all. I'm standing in the protocol that has been observed. I will be coming from the Pan South African Language Board, offering our perspective and also our concerns regarding the language practices of the Legal Practice Council. I need assistance. All right. So our role at PenSouth is straightforward. What we're bringing today is a secondary complaint taking from what Mr. Lawrence has already indicated. First of all, I will frame my complaint under the 4 contents that I've put across, looking at the Constitution, looking at the status and obligations of the Legal Practice Council, and also the impugned language practices by the Council, and also the findings that and the recommendations that we are offering as the Pan South African Language Board. We are making this submission looking into Section 11.4 of the Pan South African Language Act, which also gives the board, as the chairperson has indicated, a role to investigate the complaints and make recommendations regarding language policy and practice. And as we said, this is, at the end of the day, we're going to come with our recommendations as the Pan South African Language Board. Number 2, we are placing the submission as an additional constitutional and legislative perspective, legal perspective, concerning the language practices by the Legal Practice Council. We are saying, as the Pan South African Language Board, the impugned practices must be evaluated against the binding provisions of Section 6 of the Constitution of the Republic of South Africa, reading it together with a framework governing public administration, which deals with access to justice and equality. We also are basing our submission on the following: that these provisions that I just mentioned, which is Section 6 and Section 2, must be read purposefully and consider the transformative objectives of the Constitution and the rights which must be interpreted to advance constitutional value of dignity, equality, and freedom. We want to emphasize as the Pan South African Language Board that Section 6 is not only a symbolic recognition. However, it creates obligations requiring active interventions. And we are also saying, this is confirmed also, where the Constitution imposes positive duties, that we must adopt reasonable measures. Reasonable measures. Lastly, as the Pan South African Language Board, honing into our Constitution and the legal framework where we are bringing this submission to, is that Section 9 talks about equality and access to courts, and it reinforces the imperative that language should not operate as a barrier to participation in the legal and regulatory processes. Now, we are bringing, as Pan South African Language Board, obligations of the Legal Practice Council. Number one, we all understand that it is a statutory body exercising public regulatory authority over the legal profession. The LPC is obliged to act in accordance to the constitutional norms that I just highlighted beforehand. It is also given and established to ensure that its operations do not unjustifiably limit access, participation, on equality. Now, as the Pan South African Language Board, we made an analysis of the impugned language practices that we are complaining about. The first one is that the de facto predominance of English in the LPC candidate examination mechanisms should be looked into. We also are saying these practices are constitutionally deficient, and these are the reasons we are basing this on. Number one, as I started with Section 6, subsection 2, LPC is not complying with this section. This means that there is an absence of demonstrable measures to incorporate indigenous languages by the LPC in its examinations. And this constitutes a failure to take what we call practicable and positive measures required by the Constitution. We're also saying in our complaint that the LPC is in breach of Section 6, subsection 4 of parity of esteem and equity. We are referring you to the case by Lawrence and President of the Republic of South Africa, where it was indicated and emphasized that the state bears an obligation to treat official languages equitably, and that resource constraints do not justify inaction where constitutional mandates are clear. We also are basing our complaint on the fact that the LPC seems to be giving systematic privilege to English without a rational and constitutionally compliant framework for inclusion of other official languages, which undermines the principle of parity of esteem. We also are saying that the current practices reflect neither proportionality nor meaningful inclusion. We also, in our submission, are saying that there is an impact on access to justice and procedural fairness that the LPC should really look into. Although the LPC is not a court, we as the Pan South African Language Board, we say it performs a quasi-judicial and regulatory functions that directly affect legal practitioners and the public. Now, as we are basing our submissions, we also have findings that we are bringing across to the LPC that they take note of the following. We are saying that relevant jurisprudence and facts underlying the complaint by Pan South African Language Board should be looked into, and the LPC should also look at section 6 subsection 2 and section 6 of subsection 4 of the Constitution. And we are also saying that the LPC has failed to adopt adequate measures to advance indigenous languages to ensure that equitable treatment of all official languages is afforded. And it has failed to align its language practices with the transformative imperatives of the Constitution. Because we have come into this session to have a conversation, as we received the letter from the LPC that they are willing to have a conversation, we are coming with the following recommendations as the Pan South African Language Board. We are recommending that the LPC develop and implement a constitutionally compliant multilingual language policy, which must be consistent with Section 6 of the Constitution. We also are recommending that LPC introduced a phased-in approach and reasonable measures to incorporate indigenous languages into candidate examination processes. We also are recommending, lastly, that the LPC report to PanSouth on its progress, and we will define the time frames together. In closing, as the Pan South African Language Board, we are saying that there is a constitutional commitment to multilingualism, which must also be upheld by the LPC. This is not just an aspiration, it's something that must be done intentionally. The Constitutional Court has affirmed that the Constitution demands transformative actions, which is found in one of the recommendations that we are giving as a Pan South African Language Board. We also are saying that the LPC should adopt meaningful multilingual practices, not monolingual practices, which will make sure that the constitutional imperatives are aligned to and are followed. This is my submission on the behalf of the Pan South African Language Board. Thank you so much.
Thank you very much. Thank you very much, CEO, for that presentation. We've taken note of the presentation. I'm not going to allow for any comments or questions. It's a clear position of PanSouth that has been taken. I want to, without further ado, go straight to then raise Prof. Nwabisi Kgalagala to come and make his presentation. I trust that you are ready. Yes. Thank you, Prof. Are you amenable to go into the podium, or are you going to present from there? We please. Okay. For the purpose of the recording, that is, yes, please, we'll appreciate that. Thank you. Your 30 minutes starting.
Not yet.
Thank you.
Colleagues, friends, ladies and gentlemen, good morning. I'm sure you could do better than that. Good morning. Hey, thank you very much. Chair, I'm deeply grateful for the invitation extended to me by the Pan South African Language Board in particular to participate in this public hearing. And I'm also honored to share my independent views and perspective in my capacity as a forensic linguist, but also in my capacity as an academic. I represent that group. Now, I've put together a title and I'm sort of doing my footwork between the issue of multilingual, to be precise, multilingualism and monolingualism, and I take the stance of multilingual 10 for a good reason. And I also want to emphasize that this is an independent view, largely based on research and the practice over the years. And I'm sure some of you will appreciate this, that South Africa is one of the countries that has a well-documented research in this field. So we have really a lot of work that has been put together by even those who came before us. Hence the Pan South African Language Board, hence the CRL Rights Commission. And we as the community of practice, linguists, language practitioners, and those who are concerned about the linguistic human rights, this is the position that we need to defend and possibly give guidance. You know, as I said earlier, I represent the academic domain, which is part of my profile. And for that reason, for some of you who will know this, universities are intensive in terms of knowledge. They, by their very nature, knowledge intensive organizations. So that's where knowledge comes through, and that's where knowledge is shared, and that's where knowledge is defended. So those are some of the issues that I would want to bring to the table as part of this, discussion, and allow colleagues to sort of draw from that knowledge and see what is good, what is not good. So I've segmented my presentation into 4 waves. Now, the first wave, I want to make a statement about the language policy framework in our country, but I also want to make a statement about the Stats SA, in which I would sort of do a brief analysis of the population distribution by language spoken most in the households. And this tells us a story as to who are we representing as entities, as organizations, as the legal fraternity. Who are we talking about? Who stand to benefit from, these initiatives? Are we talking to ourselves, or are we talking to the people of South Africa? I think that's the point I would like to make, just to give you a better sense of where we stand. The second wave would be to sort of make a statement about the controversy. And Mr. Lawrence did make a point about it. I say it is a controversy because it is a controversy. So I'll make a passing mention about it and state the case about its challenge and what it has created for for some of us, not only the LPC as I was reading the document, but also in other domains. I will talk a little bit about the disconnect between language policy and language policy implementation, because that is a major problem in South Africa, not only in the legal fraternity, but in most domains. We have that difficulty. And it goes back to the first wave, where I would want to make some highlights about our theoretical standing and practice in terms of policies. But when we have to move to the next level and do much more in terms of implementation, it becomes a struggle, and which is systemic, because that's where we're falling short, and will come with all sorts of rhetoric and defend that position, talk about resources, talk about practicality, without facing the reality and the realities that our people are facing on the ground. And lastly, I will just cite one or two related literature, and then I will move on to the recommendations. One recommendation, I promise, Chair, I won't disappoint you. So this is the first wave, and I also want to make a statement here that our policy environment is up to scratch. You will find some gaps in between, because we're looking at policy from the point of view of text. We're also looking at policy from the point of view of discourse. But where we're failing is when we talk about policy as action or implementation, if you like. So that's where the problem is. Now, where is this gap? Now, I want you to look at, because I look at examples, a policy by the Department of Justice and Constitutional Development. And some of you might pick up some similar, lines from your own policies, depending on where you are located. Now, the policy reads, this policy seeks to promote the equitable use of all 11 official languages. That's the policy. And it moves on to the guiding principles and values. And it goes on to say, as this policy seeks to give effect to Section 4.1 of the Act, it is based on the following guiding principles: usage, practicality, expense, regional circumstances, the balance of the needs and preferences of the population as a whole and in province concerned, the imperative to take practical and positive measures to elevate the status and advance the use of indigenous languages of historically diminished use and status, the provision that all official languages must enjoy parity of esteem and must be treated equitably. Recognition that English is understood across the country and has become a general language of use nationally and internationally. This is a policy in the Justice Department. It's talking to South Africans. And I like this line: recognition that English is understood across the country. By who? And has become a general language of use nationally and internationally. Who says this? I'll talk about how policies are formulated. Now, my feeling here is that some of these policies, if you like, they are presented through, what we call call for public comments. But some people sit in some rooms where there's aircon and rewrite these policies for the people. And that's where the problem is. And I talk about policy as text. not as discourse, not as action. Because I cannot believe that you come across this line in any policy and this would make sense to a South African. An old lady who's sitting somewhere in Amtata, Umbu, Etzomo, and so on. It cannot be. But we find these lines in various policies. I can read it throughout, but I'm not going to bore you with that. So let me get to some of these policies. This is by no means exhaustive. You have a long list of policies which funnel down from the Constitution and other pieces of legislation, but you kind of find similar lines where indeed these policies make provision and immediately take away these provisions. Now you're sitting with a controversy. Now the policy says this, and then in between, it tells you about practicality. It tells you about resources. Now you begin to ask yourself, what is this policy suggesting anyway? So these are some of the questions that we need to be responding to as we are considering these facts. Now let's move on to what South Africans speak. Now, if you go with me on this line, the 2022 census results show that African languages constitute a whopping 78.7% majority in terms of the population distribution by language spoken in most South African households, as you can see. Now, although Table 1, now you're looking at 1996 there, Table 2, 2001, and Table 3, 2011, they might be somewhat outdated. I mean, we agree on that, by a little more than a decade in terms of the South African language scenario. But the reality in 2022, if you compare the figures, probably does not seem to show any significant difference, particularly when taken, sort of takes closer look at the overall trend, as you can see, in the 4 national censuses. Now, and this is evidenced by the consistent over 70% results that represent the previously marginalized languages, African languages to be precise, when combined. Now, further observation revealed that isiZulu remained the most spoken language in the country. I'm sure you might have seen this in recent times in other circles. So we're talking, almost a quarter, 24.4% of the population. Now it's followed by isiXhosa speakers sitting at 16%, with Afrikaans, sitting at 10.6%, holding third position, but not far away from Sepedi, for example, sitting at 10.0%. Now, it is also worth stating that proportion of individuals who speak English, Tsonga and Tshivenda, remain relatively stable. And this seems to be the trend across all 4 censuses, while a noticeable downturn trend is shown by the speakers of Afrikaans from 14.5% in 1996 to 10.6% in 2022. There could be a reason for this. And isiXhosa, of course, sitting at 17.9% in 1996 and down 16.3% in 2022. Now, the findings reveal for us that less than 1% of the population use sign language in both 2011 and 2022 census when combined. Now, the point being made here, Chair, is that although South Africans constituting close to 80% are speakers of African languages, or have an African language as their mother tongue or home language, if you like, these languages remain on the margins. With a little less recognition, I'm talking about in the legal, practice, little recognition or use, and in other domains, public domains. Now, while on the contrary, English, and to a degree, we speak of Afrikaans, which is now facing, a challenge, constituting close to 19.3%, continue to be in the center in most official domains. Now, the takeaway from this, clearly, the reality of this situation is unsustainable and has proven to be undesirable for the majority of the population whose English proficiency is low or non-existent in some cases. Now, I move on to the second wave, and I make a passing mention of the Mogoeng challenge, which was referred to by Mr. Lawrence. And I wrote a piece about this. Whilst we are sweeping the floors, others are dispersing dust, because we can read what is contained in the social contract, which I understand to be the Constitution, but this is more of a deviation from what I understand. So we know what happened on that date. And this is the reality of the situation. But then, as Mr. Rollins pointed out, we wrote an open letter to the Chief Justice wanting some answers about this reality. And I think some of the things that we considered to be important was around the grave implications for access to justice and, social justice. But broadly, the question was about linguistic human rights. And other sectors were affected by this decision, which was also embraced by the heads of court. Critical points that were raised: the constitutionality of the decision, the justification or the motivation, and whose interest was this? Was it in the interest of the public, or was it in the interest of those who are in the elite? Those were some of the questions. The other question was whether there was a meaningful engagement with the general public. We didn't hear anything about that. And whether there was a language audit nationwide to give us some idea as to what South Africans speak and what is their preference. So those were some of the important questions. We got an unofficial feedback from the Chief Justice, but not responding to us, but to the media. You can read it for yourself. It continues like that. I'm going to take my chances.
Sorry, Prof. The suggestion that perhaps we should read for the benefit of Mr. Lawrence. And there are people online who may not be able to read.
All right.
Yes.
All right. Sorry about that. Let me try. Right, it's cited from a link. Mogoeng told the media that the decision is to ensure that appeal court judges are able to work efficiently. If you are going to insist that all 11 languages should be languages of record, it means if 6 people who speak different languages are litigants in the same case, the record must reflect the evidence of each in his or her languages. Meaning when the matter is appealed, the appeal court judges, whether they know all the languages or only one of them, will have before them all those languages. The question is how they are supposed to make sense of all the language of all those languages. Carries on. It is the responsibility of the one who is unhappy with a judgment at a lower court level to make sure that the record is made available to the judges on appeal in the language they understand. Meaning, if you are financially under-resourced and you have this record either in this one language or in the 5 languages that poor persons who only has so much money available to take his or her matter to appeal must first exhaust his or her resources, paying translators into the language that will be understandable for judges on appeal. That was a comment by a member of the public. Just want to see if I can play this.
Doesn't make sense that in a country where the level of
These are views from the public at the time.
Especially a European language to translate judgments that are very important. I mean, constitutional court judgments affect almost everyone everywhere in the country, and the layman needs to be able to get it in their own mother tongue.
The problem is valid. The response could be debated. On the one hand, I agree that precisely because of various languages used in the country, especially as mother tongues, poses potential obstacles in terms of access to justice already on top of the materialist obstacles towards accessing that justice. But I think other alternatives must sort of be other alternatives sought in order to help overcome these obstacles.
Honorable Chief Justice, because we do have a point in respect of the pragmatic effect. It would then begin to make sense to one that court officials, presiding officers, magistrates, judges, and chief justices or justices of the Constitutional Court are learned people. Most of them have received their course content literally in English, or they are very able to understand English, whether or not it is their mother tongue. So therefore, in an attempt to tighten the first reason, if you like, I am apt to agree with the Chief Justice in this regard.
As much as I understand where you're coming from, I also think it's unfair. And it would actually make all of these cases inaccessible to those who want them but cannot read English. I think it creates a lot of problems down the line for those who can't read English. I mean, if they can have translating in court, then it should be easy for them to also transcribe those cases in the mother languages, at least presenting.
Prosecutors and judges things and people to jail because of that language barrier. And then now when you talk about a language which is understood by all as a restraint to make the situation fair, it is highly unfair because at the end of the day, the use of the language is a reminder to the majority again that you are not good enough, you are not good enough. So
I'm midway through. I'm mindful of time. So I'm
Okay.
closer to the end.
All right.
So we now get to the third wave, which I think is very critical because it gives us an idea as to what could be the cause of this disconnect between the actual policy and the implementation of such a policy or put the policy into action. So I'll talk a little bit about this because this is work that is close to my heart. When it comes to policy formulation and policy review, any policy for that matter, including the policy by the LPC, I think we need to be honest and we need to take a closer look at the 7 explanatory variables, or what we refer to it as 7C protocol. That is, 1, the content of this policy. Remember, I spoke about policy as text, policy as discourse, policy as action. But understanding fully the content, what does the policy set out to do? What are the goals of this policy as per your mandate? Now, how does the policy problematizes the issue it sets out to do or it sets out to solve? Are we solving anything if we are relying on a monolingual policy? And yet the beneficiaries, the people who are supposed to be gaining out of this have no clue whatsoever in terms of understanding the language of the policy. So that is the first step as human beings. The second part to this speaks to context. Institutional identity. What does these entities stand for? What does LPC stand for? What does it do? Is it sort of protecting the public interest, right? Is it recognizing multilingualism? Does it go beyond just recognition? Because it's one thing to recognize, but it's something else to go beyond recognition and see to it that there's action beyond recognition. Now, the context is very critical as I look at it. So the shape and size of this institution as it relates to the larger context of social, economic, and political realities of our time. If we are serious about addressing the problem, which we have, right, monolingual versus multilingual 10, it means the practice of context analysis should take precedence before policy formulation. Even if we're talking review, the context must be taken into account as precedence and see who are we serving in real terms. So that's the second C. The third C is commitment. Now, commitment of those who are involved in driving the policy, I think, is very important. And the people who are entrusted with this whole responsibility to implement or to put policy into action. Now, the reality for me here is that failure, in a variety of sectors, in as far as policy is concerned, is due to the lack of commitment. We talk about political will, but there's no commitment. It doesn't go beyond recognition. There must be a level of commitment. Now, what commitment means, really, for us is very important, and it could sort of be described in many ways, and as such, failure could be attributed to a number of reasons, if I may, which could include, but they are not limited to, lack of awareness. Because we talk about policy, but we don't seem to be aware of what we're talking about as to why the policy is being implemented for that matter, and lack of knowledge, and of course, understanding of the policy goals and objectives. So what are the goals of this policy? What are its objectives? What is it that we want to achieve out of implementing this policy? So that's the third. The fourth, which is capacity, which I think is equally important, is linked to the human resource and financial resources, which keeps coming back when we look or take a closer look at the various policies. Now, it also means that, understood in this way, the capacity to implement policy could be understood in terms of the availability of the sufficient human resource group, and of course, who are equal to the task. You could have people in your sector or in your entity whom you claim will be implementing the policy, but they are not capacitated enough to implement such policy. There are no resources to implement such policy in terms of financial resources. So that's very important. Now we move to the fifth one, clients, and I call them beneficiaries. This is very important because we're talking about public comments. We make the call and we make these submissions as the public, and the whole machinery is now handled elsewhere. And then when the outcome is received, you realize that this is not a true reflection of what the people said. And yet the expectation is that it must be implemented. And it doesn't really talk to the people. So we need to take the interest of the people, the beneficiaries, the clients, to heart. So that's the other important aspect that I would want to highlight. Now, communication, which is the second last. None of these policies are in the languages of the people. You can raise your hand if you have a policy which is accessible in the languages of the people. It is in English. And who has access to that? So that is a bigger question. So communication forms part of this. When we share the policy, the actual document with stakeholders, in other words, the beneficiaries, is it in the language that they understand? So that the fine print, my understanding is that the policy is a legal text. So it has that language which is not easily accessible to the ordinary citizens. So it has to be in that language that they understand. The last is coordination, which also means that whilst PenSALP, for example, is making an attempt to implement a particular policy, there has to be a working relationship between PenSALP and CRL. So that's the kind of coordination that I'm talking about to strengthen, the policy implementation aspect. There's no reason why CRL is advancing the linguistic human rights component. PenSALP is doing the same, but they are not working together. It really cripples the idea. So that's where coordination comes in. Chair, as I conclude, I want to make reference to some of the literature to say law is a linguistic matter. And whether you like it or not, language and the law are inseparable. Now, I've argued this in a number of circles, that our perception of reality mediates through language. And if our understanding, our knowledge, our command of a particular language, whether English or Afrikaans or isiZulu, is weak or poor, it goes without saying that our understanding of the world around us will be poor conceptually. That's why we experience the difficulty to communicate what we want to communicate in a foreign language. That's the reality of our time. So we cannot continue to repeat this because we know the damage it causes. So that's the argument I'm putting forward. And in our South African context, you will also realize that the setup is different. It's very problematic. When you talk about law and legal practice, there are these connections and interconnections. You're talking about issues of translation. You're talking about issues of interpreting. Crime is part of that. And you're talking about power. and you're talking about the narratives. And I've done quite a bit in terms of how police statements are recorded, which are narratives, but they are not ordinary narratives. They are legal text, which would then assist in terms of determining whether there's a case or not. And I'm sure because this is your space, some of the judges have lamented. I remember reading Judge Desai's case. I think it was a judgment on the triple murder trial, Van Breda, about the statement which was taken at Stellenbosch, which was very problematic. And you can also go back to State versus Ndlovu, the Eugene trial within a trial. And again, Judge Horn lamented for 3 pages about a statement which was constructed incorrectly by a police officer because of the English language. So we cannot continue to do this because it's really crippling the system. So let's give what I would refer to it as a right to a language. In other words, you allow and you capacitate a language to exist, but beyond existence, you allow it to grow, to blossom, and be in a position to handle any scientific phenomenon. Could call it law or science. It must be given that space. That is a right of a language. The right to language, we're talking about the people themselves who must be given an opportunity to use the language. They must exercise that right. Whether they don't use it or not, it's a different matter. So an interesting study that I came across is by De Vries.
2 more minutes.
Yes, it talks to your work, and you can just do a quick read, and the title is Legal Practitioners' Views on the Role of Multilingualism in South African Legal Practice. This is a PhD study. I just want to draw your attention to the findings. The findings demonstrated overwhelming support for multilingualism within the legal profession. 71% of the respondents regarded multilingualism as a beneficial to the legal profession. 75% believed that it is in the best interest of the clients to be consulted in their home language. And 54% reported experiencing communication difficulties with clients because of language barrier. This is a food for thought. Now, I want to end off by citing Tumundu, who poses very pertinent questions for us as South Africans. And you can just take a closer look at the questions which are really in the center of what we are grappling with in South Africa today. How can you guarantee democracy where the law of the country is not understood in the language of the people? How do you abide by what you do not know? How can you use information to which you have only limited access? How can you fully participate in anything or compete or learn effectively or be creative in a language you are not fully proficient or literate in? Above all, how can a country develop its human resource base to full potential without the language of the people? Finally, this is my recommendation. I think we need to understand that the multilingual turn represents a fundamental paradigm shift in our linguistic landscape across domains. And it requires the adoption of a constitutional mandate to stop marginalizing our diverse linguistic idiosyncrasies. Of course, instead of keeping English at the center and indigenous languages on the fringes, we must elevate all voices. If you lift the language, you lift the people. Thank you, Chair.
Thank you very much. Thank you very much, Prof. I think we can take a 15 minutes break, And then we will then resume at about 25 past. Thank you very much. Let's adjourn the proceedings.
I wasn't aware that when we met in February, you had already started to worry about what do we do next by lodging the complaint. But welcome and thank you for raising it. My name is Nkosana Mvundlela. I am the president of Black Lawyers Association. And as the Black Lawyers Association, we thrive on the spirit of the Constitution as it stands. We accept that the purpose of Section 6 of the Constitution was well intended. We also accept that 30 years on, we cannot still be talking about progressive implementation of the Constitution. We should be now counting the percentages of how much have we moved. Because as a matter of fact, we are still talking about it as the text of the Constitution. We are not talking about how much have we moved. And I was saying to colleagues here, Prof. Kgalakgala, that I would have wished that you would have brought us statistics which says how many people in each of the current institutions of higher learning in South Africa are still being taught in Afrikaans, and how many are being taught in Zulu. And those people are being taught law. It's very simple, colleagues. We must not camouflage the issue. We must not stand here and sound very intelligent. It's very easy. What is it that these institutions, all of them taken cumulatively in the country, are called upon to implement this Constitution, and which ones of these many, of the more than 26 public institutions in the country, how many of them have actually taken a stance and made a move? I can't, 32 years on, be standing in a hall talking about one painful language in this country. And I'm calling it a painful language because it is not a coincidence that we are meeting on the 18th of June in South Africa, 2 days after the 1976 Soweto uprisings. And which Soweto uprisings were not a coincidence. It didn't start on the 16th, by the way, for all of you who understand history. It must have started a month before. The planning of June 16 did not become incidental to the date. It was history in the making. It was a struggle to reject a particular language which was seen and is still seen, at least in the public aura, as oppressive. The stats that Prof. Kgalakgala has put here helps us understand as of 2022. They tell us how many people literally in the country are speaking which language. But I'm saying again, I would have hoped that this study, next time we meet Prof. Kgalakgala, would actually go to the nuts and bolts of what we are talking about, so that we do not sit with Mr. C. Lawrence being the complainant when he's not supposed to write the board exam. Mr. Lawrence is a practitioner. He's not supposed to write the board exam. He's not necessarily even sitting there with an opportunity to mark the board exam. And I do not believe that that should be where the conversation should start. That's why I'm asking how many of the institutions in South Africa are actually teaching law in Afrikaans, and when is PENSALP actually inviting us into a room with them so that we are able to reconfigure the curriculum of the LLB. And if we can do that, then we will have a different conversation, at least from where I stand. And the BLA's position about the constitutional imperatives will never change, because the Constitution mirrors what the BLA was started for in 1977. Therefore, it is not by accident that the BLA exists now, post-democracy, and we still call ourselves Black Lawyers Association. So with that said, I'm going to introduce at least one of the NEC members who is empowered to deal with legal education in the Black Lawyers Association, who's going to speak to the nuts and bolts of just the few issues that I've raised with you. And I'm very consistent about it. We support the LPC's view about English being, I think the language of record, colleagues, means language of record. It doesn't mean official language. And the fact that we are using English in this very hall must tell you that there is something right about it. So it's very simple from where I sit. So if we all can understand the language of record away from the official language, then we are going to understand what Mogoeng meant. Because there was no controversy there. There was no controversy. It was a simple thing, the language of record. How many ethnic groups exist in South Africa? At least we know we have 11 different languages. If you had a Zulu, a Venda, a Xhosa, a Tsonga, a Pedi, all of them sitting in the very same basic court of the High Court, and you had a Ndebele come in to make a presentation in isiNdebele, would you think that you are going to comprehend justice in that system? It's a simple, pragmatic conversation. We're not saying you can't write a judgment in your language. We're saying the language of court for purposes of that record, so that if you appeal throughout, you don't worry about the people sitting on the bench. You also do not polarize society by going back to ethnic lines, because it's very easy for us to be taken back to when people got into this country and separated all of you. Took the Tswanas to northwest, took the Zulus to KZN, took the Xhosas to the Eastern Cape, took the Bavendas to the northern Limpopo, and then took the Ndebeles, put them nowhere in between Limpopo and Mpumalanga. So that's unfortunate. That's where we are.
Ask you to focus on the core issue today that we are gathered here for, because I think that you are now deviating from the main issue that has brought us here.
No, Chair, with respect, I don't think that you called me here to muzzle me. I'm saying to you, I'm going to call a member of the BLA to come and speak about these things.
Yes, but can you hold on? Let's have order.
Okay.
All I'm saying to you is that let's not refer to Bantustans. The question before us here today is the language policy that has been adopted by the council. And I think that if you can confine your submissions to that, we'll really appreciate it.
It's systemic, and I'm telling you how it got up to where we are. And if you can't appreciate that, I will leave you to it. Comrade Chidi, you can address. I'm not going to actually go back to my word. I'm telling you how it came about. And I'm saying, let us not be dragged there, where we become ethnically located. And that's all I was saying to you, Chair, and thank you.
Thank you.
Thank you, Chair and the House. I think I should adjust the mic. President Vundlela of the Black Players Association, I think he set the tone for the BLA, and that is the position of the BLA. And but I'll talk to the topic as I go on. President McClone of Nadel, let me observe the protocol, or stand on the protocol already observed. Nakweli feeling yona kenziyo ke thoko. For sure, very few of you might have understood what I'm saying. And there's a purpose in me saying it. And what I'm trying to show, to demonstrate, is the difficulty we want to run ourselves into. Thinking that having many languages may solve the problems we have. In Sepedi, for instance, there are many dialects. And when somebody comes to court, for instance, because you write board of exam to practice in court in the end, you might have problems. And one of the problems is understanding what Nzio means. In paragraph 6.2 of the subpoena, this institution states that it has already advised the LPC that its language policy is improper. In our view as the BLA, this goes to show that this institution considered the policy. Thereafter, the LPC was advised. Following this, the process under which we make the submissions ensued. At the time of the submission of this material, PenSlab has adopted a position. We, as the BLA, therefore make these submissions only for record purposes, because the determination that may follow from Section 5 of the Act, we already know what it is. So for record purposes, we've got to make the submissions, and we don't believe that we are likely to influence any decision that has already been taken, that it may be rescinded and be replaced by a new decision. As the president of the BLA indicated, we meet 2 days after the 16th of June. You listen to radio interviews, people talking about the Holocaust, something that happened many years ago. They don't forget it. But as people of this country, we go about as if certain events have got to be forgotten. And by the way, events just demonstrate the underlying issues. So at the time when young people took to the streets, they were fighting the system, the entire system, but specifically dealing with a specific language, which is Afrikaans. Some of us had to change certain names that we were given. I use one name now when I was doing grade 11, standard 9 at the time, because I found it very offensive that my parents could give me that name. Unfortunately, I avoided Afrikaans even as a learner. Somehow I passed it, I don't know how, because it was very offensive. Very offensive, and it has remained so throughout. Now, we make the submissions in the context of the Constitution, and we can't forget what the Constitution provides for. And that is Section 6 of the Constitution, that the recognized languages should be promoted. One of them, of course, the language is Afrikaans. But let's not forget the judgment of the president of the Constitutional Court then, Mohammed. That is very instructive. It had to avoid a section in the Constitution because of the absurdity in the application of the section. And that is Section 241 of the interim Constitution. What the provision simply did was that a person who had instituted or who had proceedings instituted against them before they come into operation of the 1996 Constitution would have the law before 1996, the law that was applicable would simply apply to that particular person. But the person who was served with a process after the coming into effect of the 1996 Constitution would not have the old law applicable. At the center of the issue was this example that was used by the judge in the matter, whether you could impose the death penalty in one matter because the proceedings were instituted before 1996, and in the same set of facts, simply because proceedings were instituted after 1996 Constitution, if you like, the death penalty could not be imposed. And the court said, because this particular provision, its applicability would be absurd, it's going to be avoided. And the court avoided that particular section. And what I'm getting to is that it does not mean that simply because there's a provision in the Constitution, it should be applied as it is. Context ought to inform what we do. And in the context of the matter with which we deal, there are only two languages which have been developed sufficiently, and they are languages of record. That is Afrikaans and English. Once you insist on English, then you indirectly you are doing away with Afrikaans. And this is what has brought us here. This is nothing else. we've been discussing here. I don't know what is recession in Sepedi, and there's no concept, and I was never taught in Sepedi. So if we sit here and PenSlab decides, as it appears to have already decided, that it's going to be on the side of the complainant, it simply opens the way for Africans. But it appears as if it opens the way for everyone else, when that is not going to be the case. There's only one empowered language, it's Afrikaans. Judge Lamont says the following in the matter of AfriForum and Mr. Malema. People immigrated and continue to do so to the Republic from Europe and elsewhere. They brought with them their language, cultures, moralities, laws, and customs. Immigrants from Europe gained control of the country. They were able to and did, to a large extent, impose their norms, customs, morality of their former societies upon other inhabitants of the Republic. He says further, a fraction of the immigrants from Europe who had their origin in Holland, France, and Germany banded together at a point in time in consequence of conflict between European fractions or factions. This faction, in brackets, quote, known as Boers, close quote, in the pursuit of freedom left the community of European settlers and went to live on their own. The Boers were able to seize control after the elections held during the late 1940s. They pursued a policy of apartheid. That policy, at the time the community commenced practicing it, had deep-seated, long-standing recognition in the Republic. Ever since the first immigrants arrived from Europe, they had had no regard for the rights, social, political, economic, or otherwise of other persons inhabiting the Republic. The Boer numbers were fewer than those of other communities. I pause here.
Sorry, sir. Can you please make me understand?
Correct.
What is the relevance of that submission? Because as I indicated to your president, that today's gathering is really to look into the language policy of the NPC. Can we confine your submission to that? Because we don't want to turn this thing into a political arena.
No. Chair, I'm reading a judgment of the court. Number one, it's jurisprudence. Number two is historical context, how we arrived at this point. That the two languages, which are European languages, Afrikaans as well as English, are the ones which are likely to benefit from this process if PenSlab were to adopt the position that it appears to have adopted already. That is the relevance of this historical context.
Proceed.
Thank you. So as we say, Afrikaans indeed was imposed on the indigenous people. Lastly, on the point relevant to the one I've just made, is a judgment of the Constitutional Court. It's a concurring judgment of Justice Jafta, who agreed with Mogoeng in the street naming judgment in the Constitutional Court. He says, I'm troubled by the statement in the second judgment, which implies that a cultural tradition founded in the history rooted in oppression may find recognition in the Constitution. And it cannot be gainsaid that the oppression we are talking about here was based on race and therefore was racist to the core. Its central and yet false pillar was that white race was superior to other races. The BLA says that this policy will benefit Africans and that should not stand as a case. He says further, the Constitution retains from the past only what is defensible and represents a decisive break from and a ranging rejection of that part of the past which is disgracefully racist, authoritarian, insular, and repressive, and vigorous identification of and commitment to a democratic, universalistic, caring, and aspirationally egalitarian ethos expressly articulated in the Constitution. At the center of the statement by Judge Jafta is simply that from the past we should only retain what is defensible. And as we know, and it's a point I made earlier, Africans represented oppression to many black people in this country. And I think that still remains the position. So what we have now, Chair, is that it's a battle between two languages. One is English. The English person doesn't have a problem. They are in England, they are relaxed there. They don't have a problem. We are fighting for them. And we've got a problem because Afrikaans is here. And we are saying, go. We've got it's a very serious problem. It's not a simple one. So we are here, we're supposed to work together. They are having it nice in England. And we are fighting. And this is what they wanted. Of course, they conquered the whole world, if you like. And that's why the whole world speaks English.
You've got 5 minutes left. Just manage your time.
Yes. So what then, Chair, needs to be taken into consideration is that in addition to, we've got another problem, in addition to English and African, there's also Latin. There's also Latin in law. It's a third language from Europe. And we seem to think that these are not problems. So what we should do as a people, we should say, we can't act as if Afrikaans is not spoken in this country. But the African-speaking people need to understand that they oppressed us and we didn't like it. And we still suffer the consequence of that oppression. So being faced with that language again would continue to be offensive. And we should not have it, at least at this point. Now, when we study maths, we study maths to resolve problems. What then should be the solution? Because we've got a problem of 3 languages, English, Afrikaans, as well as Latin. None of them African. And if we were to commence a process to have my language spoken, it's only after 30 years that that language would be sufficiently developed, because you would have to move from grade A to university. There should be a professor in that language who would be developed and all of those. It's a long process. But to immediately open it now, it benefits someone immediately, which is African. So you need to be careful of that. What maybe, and the president suggested that maybe we could have a round table and perhaps consider the options that we have available to us. There's nothing. Afrikaans was developed, as I said, from German, French, as well as a language from Holland. What stops us from developing? There are 3-4 languages identical in this country, but many words in many tribal groups are similar. And there's nothing that stops you from developing one uniform language. And I want to say this. If you were to develop that language, and it's something that this institution can sit with, if you were to develop that language, it must amalgamate all indigenous languages. And for the first time, this country, in years to come, not now, we can't be too ambitious and think that it will happen now. For the first time, we subject Europeans to our language and we make it an official language. And for them, for the first time, to be compelled to learn a language that is developed from this continent, amalgamated from different languages. So that
time is up now.
That is food for thought, Chair.
1 more minute.
Yes, that is food for thought, Chair. Think about that. We can talk about it some other time. But for the purpose of the complaint with which we are confronted with,
yes,
what ought to happen? Unfortunately, we need to stick to the Englishman. Unfortunately. And later on, find solutions, inclusive solutions, not solutions that would favor one language over any other language recognized in this country. Unfortunately, the very reason that you could not understand Nzio is because we have invested so much in English. And for us to move away from it, it will take us generations. Thank you so much.
Thank you. Thank you very much for the submissions. Colleagues, can I just caution that let's not make gestures and speak harshly when somebody is presenting, because it's simply interrupting the record. And also it's a distraction. If you could please just maintain the decorum, I'll appreciate that. I'm going to open then to the committee. If they've got any questions or anything they want to say to BLA, it's open. Thank you.
Okay, Prof, proceed.
Thank you very much. We appreciate the presentation. Luckily, on 16 June, I had the privilege of being in one of the events where we were discussing language issues, and we were honored by the presence of the stalwarts who experienced the pain that operation came with. So trust me that my comments will come in from a little bit of informed point of view. I appreciate the fact that you are indicating that Afrikaans is a painful language, but I also want to call on us to be able to make a distinction between Afrikaans as a language and Afrikaans as a system of operation. If we are able to draw the distinction between the two, we will be able to say in the decisions that we make, we don't make the young generation that speaks Afrikaans to pay for the sins of those who oppressed us. We have colored people who are speaking Afrikaans, who are Afrikaans speakers. We have black people who are Afrikaans speakers. So I just want us to also draw that distinction. Secondly, I should also indicate that the language that I'm speaking right now is also a painful language, because before Afrikaans can become a painful language, English was that language that was forced down our throats as well as indigenous people. So I would then ask, what informed the decision to choose a better devil? Because if we are to argue this from a political point of view, as you have opened that door, that will be what it is, that English is a better devil, because the people who are making decisions right now have not experienced the pain that came with English, because those who experience this pain are no longer there, but we are having those who are experience the pain that came with English, because Africans represent apartheid and English represent colonialism. But I want to ask that question, to say, when the and you indicate that BLA supports LPC in the decision that the language of record will be English. Prof. Kgalagala presented to us the stats, or that came from Stats SA. Having looked at those stats, seeing that majority of the speakers, by the way, Nagamo Pedi, Sarashuki Spedi, and I know that many will not understand that. So I want you to know that my question is based on the stats that are presented to us, to say we have isiZulu as the language that is spoken by many of South African as a mother tongue. Why the choice was not informed by the states, and what informed the position that you are supporting as BLA, to say that you support the adoption of English, because there are those who are feeling oppressed by English. I come from an institution of higher learning, and I can inform you that there are students who are suffering because they are expected to learn in English, and they're expected to be assessed in English. So they are being their rights are being undermined as well. So my question is around that, to say, what informed this decision to say English will be the record, the language of record? Thank you, Chair.
Thank you. Let me take the second question and then you can answer them.
Okay, thank you so much for that presentation, and I will go back a bit to the elaborations by the BLA president, who clearly indicated and said that English should be the language of record, right? So I'm sitting here in another cap, being an anthropologist, and we all have our programs in front of us in different languages. And the language that I can fully understand, Sesotho sa Leboa, Sesotho, but I'm referring to English. And I'm just wondering how many of us here are referring to different languages, or have we focused specifically on the English language? And I'm currently reading a book, All Wise, a judicial memo by one of the authors in South Africa and a judge, and it's in English. So from my own perspective, I am recording my knowledge or wisdom in English, simply because when I go to Exclusive or any other bookstore, you won't find some of the languages that I understand, Sesotho sa Leboa or Sesotho. So I feel as if I am, for lack of a better word, forced to read in English, but I'm recording in English. So I think from where I'm sitting, and also looking at the presentation by Prof. Kgalagala, to say that yes, most languages that are spoken in South Africa are there. I mean, Sesotho, Sepedi, isiZulu, and so forth. We have the vast majority of people who speak different languages in the country. And why then promote or only record English or prioritize the English language in the land of where we have multilingualism in the country? In my other head, what then comes out very strongly is the issue of promotion, development, and protection of languages. And I think the clarity seeking here would be in two parts. The first one, in terms of the English language being the language of record, then what happens to the other languages? What are we saying in terms of having to develop, in terms of promoting, in terms of protecting the many other languages in our country? Do we then not think that as a way forward, we then need to be solution orientated to ensure that we do not marginalize, exclude, or even practice issues of inequality in our country? So I think, Chair, let me leave it there before I start repeating myself. Thank you.
Okay, thank you very much. I'm not sure, President of BLA, with your executive, who's going to answer, but I'm going to leave it to you.
I hope it's audible, Chair. Thank you. Thanks to the members of the board who asked. My sister, I agree with you fully. I think if anybody heard what I said at the beginning, was you do not start a language at exam point, and that's my point. With everything that I've said to you, is you do not start a language at exam point. You start a language at a developmental stage. And if you start a language at a developmental stage, you will get to a point where you ask the LPC, why, when law is taught in Zulu, why are you giving people exams in English? And that would be a correct question at the time. And that's all that I was saying. I'm saying to you that developmental process that the CEO talked about, that is required by Section 6.2. When does PENSAL then say to us, we have had this engagement with Parliament? Have that public conversation with Parliament and say, these kids that goes to these schools, are they being taught in the languages, these very complex subjects that you're talking about, math, science, and so forth, are they being developed in language, indigenous languages of the people we are talking about? You may be paid, my brother. The reason you are called professor today is because you studied in English until up to where you are. It's simply because the English language had been developed to have the concepts that led you to write a thesis in English. Can you write a thesis in Zulu today? Maybe. Can you write? No, it's fine. You can agree.
Colleagues,
But believe you me,
colleagues, let's give him a chance. Let's
it
give him
is
a chance.
it is not as often as you would find it in a court of law, where you're going to have all the other concepts being available for you to be able to develop the judgment you want to develop, one, or the trial as you'd want to have it. And because our South African court system, it is hierarchical. You start with magistrate, now you are even going to start with the traditional courts and so forth. And then you go to the apex court, which has only 10 judges or 9 judges. What language do you want them with ease to actually come to a judgment that would be read throughout South Africa with the same understanding? And that's all that the BLA is saying to you, that we are not choosing a better devil. We are saying develop all other languages progressively to get to a point where you are able to hold people accountable. But without that process, you cannot be then punishing people at the end for not issuing an exam in a particular language simply because you have not developed all the other languages. You may as well be seen to be giving advantage to the developed languages without necessarily having a program to develop the other languages. And that's all that we are saying to you. Thank you.
Thank you. Thank you very much. I think let's proceed then to the next. Chair, I know that you've requested that we give the presentation of the prof and opportunity for questions. We'll do that. I just want to move to the next association, Nadel, to give us a presentation. Okay. In the interest of time, I'm going to take the 2 hands, but please be short. I'm going to start with Professor and then come to you, Mr. Lawrence. Is that fine? In that order. A clarity seeking question and a comment, not necessarily a cross examination of any sort. Okay.
Sorry.
Okay. Hold on, Prof. There's a hand. Let me hear this hand.
I just want to get some clarity because we have got a program and it does not provide for what you're doing now.
Well, these are comments based on the presentation.
No, but I mean, look at your program, actually what it provides for.
Okay, fair point. But earlier on, we did take comments. I did allow. Hold on. I hear what you're saying, but I'm going to make a ruling that I'm going to hear their points and then we'll move on. So I'm going to hold on, sir. I've ruled on this point. Let's not do the back and forth. All I'm saying is that I'm going to give Prof a chance. I'm going to give Lawrence a chance. Just briefly, please, just a comment. It's not a question, just a comment. Thank you.
I'd like to stand on Nekliwa because you're saying it's a comment before you even ask the question or he even speaks. You don't know what he wants to say.
I've ruled on that, so we are proceeding. Proceed, sir.
I think in the interest of, a peaceful engagement, let me withdraw and then we can proceed. Thank you.
Mr. Lawrence, do you still want to make a comment? But please be brief.
Very brief. Firstly, in the judgment of the University of Free State, Judge Furaneman recorded it's not a language, it's a people. who are committing wrongs, not a language. Otherwise, German, Spanish, etc., wouldn't exist. English. So that's one remark. And then I just want to ask the chairperson of BLA. We were there in Umtata. Is that accurate? And there I understood the BLA to have a position that it's pro the development of the and pro the change of the language of a record position. So I'm a little bit confused now because I was there and I thought.
Mr. Lawrence, please wrap up. We will take that question at the end.
Okay.
But I think they've taken note of that. Can we then move to the next presenter, please?
So can I record one?
Sorry, let's allow them to make the presentation. We will entertain the questions at the end.
Chair, good afternoon. My name is Machini Mutloung. I'm the president of the National Association of Democratic Lawyers, NADEL. I'm also the president of the Law Society of South Africa, but I stand on this podium wearing the hat of National Association of Democratic Lawyers. Chair, I just want, just for purposes of my presentation, to at least run smoothly and uninterrupted, I made an observation that it would appear that the latter presentation by my fraternal legal body BLA was interrupted in the event that some aspects of my presentation seem not to be relevant, but for purposes of context, may I be permitted to pursue the line of my presentation. Otherwise, if I'm interrupted, I might lose my chain of thought. The National Association of Democratic Lawyers stands here today to address the complaint submitted to PENSALP by Mr. Lawrence regarding the LPC language policy. His objection is simply that the candidate attorneys and people's examination, which is the competency-based examination, must not only be completed in English. This extends to examinations for conveyancing and notary public. My presentation sets out NADEL's position, and I'm going to contextualize the issue within South Africa's painful history, legal realities, and practical consideration. As I do so, Chair and the House, I'm going to, by all means necessary, avoid being euphemistic about it and deal with the issue that is confronting us head on. This is but the elephant in the room. We strongly assert that the complainant's argument, which I attentively listened to when he was making his oral submissions, and I've read his submissions, but his arguments disregard historical truth and the complexity of multilingualism in the legal sphere. Now, If we can zoom into the historical overview, and it will be remiss of me not to address it from the point of the dominance that Africans has had within the legal space. For decades, Africans dominated South Africa's legal and judicial environment. The court proceedings, legal education, and professional advancement were often accessible through Africans. And this had direct consequences of marginalizing indigenous languages and reinforcing systemic exclusions. And the legacy of Afrikaans as the language of power in law is undeniable and forms the backdrop for current debates about language policy. Ignoring this history is to overlook the lived experience of countless South Africans who were denied justice and opportunity. What the complainant ignores is that he failed to acknowledge the reality of South Africa's linguistic landscape. The country's legal system was shaped by historical injustices, with English and Afrikaans used to exclude the majority. The painful truth is that the transition to English as a language of legal record, and need to emphasize, it's the language of legal record, is not merely a policy choice. It is a corrective step towards broader access and equity. The complainants focus on Africans disregard the ongoing marginalization of indigenous languages and overlooks the need for practical solutions that serve all South Africans. Now I would zoom into some of the propositions that the complainant put forward as a way of turning the situation around. He talks to a language plan which would, in his view, address the issues of reduction of court backlogs. The suggestion that a multilingual language plan would alleviate court backlogs is overly simplistic. Court delays stem from complex procedural, logistical, and resource issues, not merely language. Introducing multiple languages without addressing the lack of qualified interpreters and legal terminology would further complicate proceedings. And what he was proposing is nothing but an imaginary world, where we have a situation where a court sitting in Putadichaba, simply because Putadichaba is dominated by Sesotho-speaking people, that a magistrate or a presiding officer would also be Sesotho-speaking. A defense representative will be Sesotho-speaking. An accused will be Sesotho-speaking. A witness will be Sesotho. All parties in that court, simply because of their geographical position, will speak a language dominated in that area. That is overly simplistic. It does not work like that. So inevitably, the use of interpreters will still find its place in a court system, in a courtroom, based on a variety of issues, including multiple people in the room speaking different languages. By the way, if he was, as an African-speaking person, go and appear in that setup, that imaginary setup, would he be in a position to follow the proceedings conducted in a language that he doesn't understand? The reliance on interpreters presumes an established and standardized legal vocabulary in all languages. The fact that an interpreter misunderstood or misconceptualized issues that were discussed were ventilated in divorce proceedings does not necessarily mean that the interpreters are infallible. They are fallible. They are subject to be corrected at any given stage. That cannot be used as a point to advance the argument that he did. Currently, such terminology does not exist for indigenous languages. And this would risk miscommunication and injustice. But what are the practical challenges with regards to multilingual court proceedings? Bearing in mind that the language of record for now is but English. If we are to gravitate towards multilingual court proceedings without having laid a proper foundation, because what seems to be coming out here is that a situation where a house is built by starting with the roof, it cannot be, and ignore the foundations, the foundational imperatives in building a language. It's something that we should not lose sight of. There is no standardized legal terminology in indigenous language or languages. I do a lot of commentary at Lesedi FM. It's a Sesotho radio station. Just few weeks ago, I had to do commentary on the latest decision regarding cryptocurrency. I had to interpret to millions of listeners of Lesedi FM and tell them what cryptocurrency is, let alone telling them the legal concepts developed in that case. Just last week, I had to interpret on SABC News the implications of an interdict that the President of the Republic of South Africa launched. I had to do that in Sesotho. This goes into the heartbeat of us having to seriously consider developing our languages before we rush them into a legal system and get a result that would not have been intended. It will be calamitous of us to impose languages at a level of writing board examinations when students or candidate practitioners, both pupils and candidate attorneys, would not have received any training in their indigenous languages. By the way, as NADEL, in 2017, when we were celebrating our 30th anniversary, we held or hosted a conference under the theme Decolonization of the Law. Decolonization of the law is a non-negotiable when it comes to our legal system, but it has to be done in a constructive, in an orderly, in a structured manner. There is mentioning of the 1976 uprising. It's an inevitable, Chair and members in this room, not to revert to that proposition, because it's a proposition that was presented here by Mr. Lawrence. But what I understood him to be saying is actually a misinterpretation of what that painful event was about. He uses this to support his argument. This is a misreading of history. The uprising was a protest against linguistic oppression and exclusion. That's what it was. The struggle was for freedom and equality, including the right to access justice and education in languages that do not perpetuate exclusion. Neglect of indigenous languages. He's saying we are neglecting indigenous languages. That is not true. What we are here for, here today, is to debate whether or not, as we restore parity, that we should go to a default position where English and Afrikaans had equal standing as languages of record in legal proceedings. Because inadvertently, what they seek to achieve, or what he seeks to achieve here through this engagement, is that conveniently all indigenous languages should be languages that are used for purposes of examination. But his failure to address the lack of development of other languages, because Afrikaans has been developed, it was used. In actual fact, and we should not be euphemistic about this, in actual fact, in some instances, during the erstwhile law societies, history will judge us harshly if we do not say this as it is, that many candidate attorneys complained that when you are English speaking and when you rather write in English, you stand a chance of failing. It was there. And when you write in Afrikaans, you are passing. Now, we want to restore the status quo, to restore privilege. We can do that. All things but equal, we can, and we actually support the use of all languages as recognized in our constitution. But Africans must also stay, just remain there until our languages, other languages, are also fully developed and we start on a clean break approach. True linguistic justice demands addressing the development gap and creating opportunities for all South Africans. That's true linguistic justice. Not reverting to a system that privileges one language at the expense of the majority. The constitutional and legal argument, in as far as Section 6.2 of the Constitution is concerned, this section mandates the development of indigenous languages, not the preservation of historic privilege. The LPC's policy aligns with constitutional objectives by promoting access and fairness while recognizing the practical limitations in the current legal environment. Reference to Magistrates Court Act as a creature of statute, well and good, but how does it advance the argument? Because English is the language of record in courts. So conveyancing, registries, and other processes are already using English. It's more of us aligning whilst we are in the process of developing. There is no argument about whether or not we should not develop. We should develop. The standardization is essential for legal certainty and professional mobility. English is the language, as indicated, of record, not just an official language. So standardizing examinations in English ensures all candidate attorneys and pupils are prepared for professional realities they will face in courts. It guarantees legal consistency and facilitates access to global legal resources. The absence of standardized legal terminology in indigenous languages makes English the only viable option for now, while the profession works towards developing and uplifting indigenous legal vocabularies. If you are to move an application for mandement funds, Poli. How do you say it in Sesotho? Without us having to develop it. Indigenous languages and legal terminologies must be developed. So legal, we are saying as Nadel, LPC's policy is not a rejection of linguistic diversity, but a recognition of the urgent need for capacity building and terminology development. Nadel supports efforts to expand legal education and resources in indigenous languages, but this must be a gradual, deliberate process rooted in the realities of the legal profession. The systemic privilege and exclusion argument that was presented here, the claim that the LPC actively perpetuates systemic privilege by excluding indigenous languages ignores the foundational prerequisite of legal testing. A professional board exam is a tool used to measure standardized competency, not an institution designed for linguistic development. Because the legal terminology, standardized precedents, and statutory annotations have not yet been technically developed or codified in most indigenous languages. We're saying our people want to read legislation in their own languages. What are we going to say in those legislation? Mutatis mutandis. What are we going to say in that? The issue of us having to develop, it's something that we cannot ignore. The non-compliant argument. The critics argue that the predominance of English in LPC entrance exam is legally non-compliant. This argument is undermined by the fact that LPC aligns the testing directly with the judiciary's operational norms. Since English is officially the single language of record across South African courts. So the LPC is mandated to ensure that candidate practitioners possess the professional proficiency required to litigate, draft, and record within the exclusive medium. So testing in undeveloped languages will fail to assess actual courtroom competence. I'll fail. If I wrote board exams in 1999. If I was to, I'm still training candidate attorneys now. I would have to train them in Sesotho. If I were to write, I'll fail because I studied law in English. The failed mandate argument. The argument that LPC has failed to state its statutory language duties is weak, because it ignores the constitutional standard of reasonable practicability. It must be reasonably and practically possible. So under Section 6 of the Constitution, state entities must balance language promotion against resource availability and administrative functionality. Forcing a regulatory body to design, moderate, and create complex conveyancing and notarial exams. Not sure if we understand those concepts in conveyancing in notarial practice. Notarial practice actually uses Shakespearean language. Already being English speaking, it's still a very difficult examination. So imagine if this was to be done in our 11 different languages. There has to be, without uniform, peer-reviewed legal vocabularies would collapse the professional intake system. Now, recommendations demanding that the LPC immediately develop and implement multilingual exams are legally flawed. The LPC does not possess the statutory power or the mandate of an academic institution or a legislative assembly, forcing it to single-handedly generate legal vocabularies places an improper institutional burden on a regulatory body that has no curriculum building function. NADEL, in conclusion, as we reaffirm our position, NADEL stands firmly behind the LPC's English-only examination policy. This approach confronts the painful truth of our history, addresses practical realities, and aligns with constitutional imperatives. We reject, in the strongest terms, Mr. Lawrence's arguments as simplistic and historically uninformed. Our commitment is to a fair, accessible, effective legal system for all South Africans while supporting the long-term development of indigenous languages. The future of South African law lies not in returning to the privileged past, but in building a just and inclusive profession. Chairperson, I am 24 minutes, 45 seconds, and I rest my case. Thank you.
Thank you very much. Thank you very much for the presentation. I'm going to take the next presentation before we take questions. And that presentation then comes from NBCSA. Are they here? Okay, excellent. We will come to that. Sorry, Mr. Lawrence, we will come to that. Let's allow the presentation, and then after that, we can entertain questions.
Good afternoon, Chairperson. All protocol observed. My name is Advocate Carol Mobu, representative. I'm not the president. I'm the representative of the.
Okay, noted.
Yes, I'm the representative of the National Bar Council of South Africa.
You're welcome.
Thank you, Chair. My presentation today, it's the National Bar Council of South Africa was established in 1994 and also recognized by the late Honorable Justice Dula Omar. He entered the legal profession first as an attorney and then later converted to be an advocate for transformation, which signaled the fusion of legal practitioners in the legal profession. His recognition for NBCSA as the first alternative bar association to the General Bar Council, which is GCB. Their society were first received as radical or rebel. The legal regulatory body then communicated in the official language, which is English and Afrikaans. The sustainable of this language policy required the regulatory policy of rules and acceptance standard and norms of the professional legal services. I submit, Chairperson, the legal profession, including the NBCSA, sustain this vision. Now I'm going to touch on the issue at hand for today, which is the constitutional imperative. The objective and purpose of the Legal Practice Act 28 of 2014 regulate the powers of the respondent and direct purpose of this act to provide legislative framework for the transformation and restructuring of the legal profession that embraces the values underpinning the Constitution and ensure that the rule of law is upheld. The complaint heard today is about the underpin of constitutional right regarding the language policy and the right to fair administration. The Constitution is a prism through which public bodies should perform its obligation to the citizen and those who live in the Republic of South Africa. By virtue of Section 6 of the Constitution, a Pan-South African Language Board established by the national legislation which promote, create conditions for the development and the use of all official languages. It is submitted, Chairperson, that the complaint has the local stand to subpoena and conduct a hearing to investigate the policy of bodies who serve public interest, which hamper the development and the use of official language, such as Afrikaans, Sepedi, and Xhosa. These are just the example, Chairperson. Section 6.2 of the Constitution, which also provide the recognizing the historically diminished use and the status of the indigenous languages, like my previous colleague has already alluded on this point, of our people, and also to take practical and positive measures to elevate and the status and advise the use of these languages, which we have 11 official languages, Chair. An argument with reference to the national anthem manifests the use of different official languages in lyrics to promote the nation building and the stigma of Afrikaans that has become irrelevant. The complaint submitted, Chair, as NBCSA that was placed before this hearing clearly represent the ground of a case to be made out of that of LPC that has directed that English should receive preference above the development of other official languages. It is arbitrary and defies Section 3B of the LPA, measures that languages provide equal opportunities for all aspirant legal practitioners in order to have a legal profession that broadly reflect the demographic of the Republic. As I've observed on the complaint lodge, Chair, by legal practitioner, the objective that he cites is rational and applies to other indigenous speaking languages to our junior as well. The NBCSA footprint extends to members participating at the seat of every local division in our High Court. NBCSA hold the view that people from different cultures background, including Xhosa-speaking communities, face prejudice and unfair administration by not being able to access to examination in the language of their mother tongue and official language. On this point, we refer to the Gazette publication, which was published in 3 official languages. The hearing that was done and also published, the topic of the article is The Hidden History of Afrikaans, which was published in 9 October 2015, Chair. English is an African language with its primary speech community concentrated on the African continent. Today, 6 in 10 of almost millions English speakers in South Africa are estimated to be Black in the generic sense of the word. A figure that will, by all indication, increase significantly in the next decade. Like several other South African languages, English is a cross-border language spanning sizable communities of speakers, like in a place like Namibia, Botswana, Zimbabwe. In South Africa, English is spoken across all social indices by the poor and by the rich, by the rural and urban people, by the undereducated and the educated people. English is a Creole language. It shares strengths common to languages in the Caribbean Peninsula, Indonesia, northern parts of South America, Eastern Africa, Niger, Congo, and Kiswahili. In the article of the language question in Rainbow Nation, the South African experience, 1997, 12, Dalhousie Law Journal, he also referred at 10 the strategic balances that had to be struck. In the judgment of Sech J, remarked that speakers of other languages, the enforce of English could be seen as an inconvenient and suffocating and inducing a sense of disempowerment and exclusion. In a sense, all languages are right against English, which in the modern world is such a powerful language that it needs to be protected at all costs and tend to resist being slaughtered in any system of right. In conclusion, Chairperson, Section 29(2) of our Bill of Rights recognize and it accords the right to receive education in public educational institution in a language of choice, where that education is reasonably practicable. In this, the Constitution accord the international instrument. And BCSA contend that it is reasonably practicable to provide examination papers in all other indigenous languages and official languages. I submit, Chairperson. Thank you.
Thank you. Thank you very much. Round of applause. All right, I think we have now listened to all the voluntary associations. The next presenters now is going to be the LPC. Yes. Yes. No, it's fine. I think let's then take those comments that we had put on hold before we take LPC. I know there were a few hands. These are comments, colleagues. As I said, that we're not going to cross-examine anyone. All we're doing is just asking questions of clarity and getting more information. So I want to start with Prof because the hand was up first, and then I'll come back to you. Remember, you're the complainant. I've given you enough time to talk today, so I want to give us an opportunity. I'll come to you. Hold on. I've not given you a chance. You are not on the floor. So, Prof, please proceed.
Thank you, Chair. Just a couple of comments. I really worry when we pull a political argument in a space where we have to be driven by a linguistic human rights argument. It's a shame that we are driving that argument, to its conclusion, not its logical conclusion. And I just want to put it out there to say it is a problem. I would listen carefully if we were driving this from a different angle, because the danger about a political argument such as this one is that we are saying, as representatives of these very important organizations, that there's no hope for your own languages. That's what we are saying. That's the implication of it. So your own languages, it means they may not have any capacity whatsoever to handle scientific, legal phenomena. That's the message that you are sending. I would hear you better if you were coming up with a different angle altogether. And from an informed position, let me go back to the foundation. I mean, there was a comment about the roof being a starting point if you are building a house. For your information, we are now looking at mother tongue-based bilingual education, which is happening in basic education. In other words, we're looking strongly at the incremental introduction of African languages. As a matter of fact, some of the exams, assessments, are written in African languages. Some of the exams, for your information. Now, at university, all 26 public universities have been given a mandate by the former minister, Blade Nzimande, to take forward the issue of the development of languages that have been, for the longest time, marginalized. Now, it's happening in universities. So the analogy about the roof, it's irrelevant. I think it's being shared from a position which is not informed. I'm sorry. So there are very important movements that are happening in our spaces. I did mention earlier on to say,
Prof, please summarize.
Let me stop there. But I think the point I'm trying to make is, let us speak from an informed position.
Okay.
And
Point
also,
taken.
let us at least present a progressive view as Black people. I'm now
Okay,
saying
Prof.
as Black
I'm
people.
going to stop
because-
you there.
Yeah.
Let's move on.
Okay.
Prof, I'm going to give you, but before Prof, I think the doctor there has not spoken, so I'm going to give you an opportunity to comment.
Thank you, Chair. Thank you, Chair. It's a clarity seeking question to the President of the National Association of Democratic Lawyers. You touched on interpreting in the LPC. Section 6.3 of the LPC language policy states that you provide interpreting or translation services the service is provided by the provincial council employees. So what I would like to know is, do you only use the PC employees or also use qualified language practitioners? Why that question? The qualified interpreters have knowledge of the legal terminology. You mentioned that there's no standardized legal terminology. Independent, I understand that comes with financial implications as well when you sort the services of an interpreter if you don't have a language unit in your institution. The qualified language practitioners use accurate terminology. Yes, people sometimes, we see in the courts where interpreters sometimes make mistakes, but someone who has not been trained as an interpreter, I think it will be worse than when the service is rendered by a qualified language practitioner. And doesn't that as well cause conflict of interest when your employee is interpreting, trying to facilitate or assisting the complainants who are complaining about the services of the legal practitioners? And again, my understanding is that people might have personal biases and also compromise the neutrality of the complaint process. I will end there concerning the interpreting services. Otherwise, on the language division, I'm partly covered by Professor Khala. I concur with him that the language development vehicle has already been set in motion. MT mother tongue-based education has now been rolled in intermediate phase, where they do different kinds of subjects, including the technology. Yes, our languages are evolving, but the professional language practitioners have. Okay.
Thank you very much. I think the point is well taken. I'm not expecting an answer. Remember, these are commentary. We're taking note of all these submissions. I see hands, but hold on. Let's give the professor here to have a bite.
Thank you, Chair. Let me first start by appreciating the 2017 conference where decolonization of the law was the topic of the day. I think that is an important move that we need to partake in. And also touching on what Prof. Khala has said, I think nowadays with the introduction of AI, we are able to build a house starting with the roof. Institutions of higher learning are doing that. The notice that is before us indicating that LPC examination from 2024 onwards will be offered in English only, which is a notice that you support. I want to check if there was a consideration of learners and students who did not do their basic education in English. We know that majority did basic education in English, and those who would take this examination, some of them would not have done their basic education in English. And I see that the notice was out on the 13th of December 2023, which means that effective immediately the examination will be in English only. Couldn't there have been a phase-out approach, at least, to say that we take into consideration? I think there's also an argument that says if you haven't done your basic education in Sepedi, for example, you can't be expected to take examination in Sepedi. But because of the political position that we are taking, we are ignoring the fact that there are those who did not do their basic education in English. What are we saying about those? And part of those, and I want to emphasize this, part of those are students who share the same skin tone with me. Part of those are our nieces, our brothers and sisters. Couldn't we take into consideration to say, let us have a phased-out approach so that as we do I don't think this will be redress. I don't know what will be the term for that. But whatever term is it, Africans, ba ile gore ba le busy ba dira thuto ya bona ya fatshe ka Africans bona re reng ka bona. I think that is also something that to consider. I understand where we are coming from. All of us, we share that pain. Some of us, we lost parents during that struggle. We know, we have lived that experience. But we also acknowledge that experience have created a room for some of us to have education in Afrikaans. What are we saying about those? Thank you, Chair.
All right, thank you very much. I don't think there's any other hands. Doc, you covered.
No, basically what I wanted to say, that I think we need to understand the main objective of today. The main objective of today is to listen to the complainant and listen to the respondents, right? This is a public hearing. All the information gathered here will assist PenSelf in preparing a recommended document for the powers be. So I don't think so we are competing here. We must not ever think that here we are finding an ultimate winner this afternoon, right? Tonight when Bafana play, we'll find it ultimate winner, right? But the purpose here today is just to listen to all points so that we can go forward. I just want to make an appeal because I can see people are getting heated. Thanks.
No, thanks for that, Doc. Okay, based on those submissions, can we please just be brief so that we can move to the next presenter? I'm giving to you, Mr. President. Thanks.
Okay, thank you, Chair. Just a few points of correction, and I appreciate the sentiments expressed by Prof. But let me disabuse you of your position about presenting a position of NADEL from uninformed. I think it's just overstretching it because, and I don't think you understood our position accurately, or you captured it accurately. What we're saying is that NADEL supports efforts to expand legal education and resources in indigenous languages. But we put a caveat, and we're saying this must be a gradual, deliberate process rooted in the realities of the legal profession. And perhaps the emphasis on us presenting arguments from a political view, there is an interconnectedness and interface between law and politics. In any event, inevitably, there is that interconnectedness. But further,
let's sum up.
Yes. Further, the efforts that you're saying the former minister has put in place, I'm yet to hear a law student doing insolvency law in Sesotho to this date. And that talks to gradual development. Perhaps it's at infancy stages, but we know how long that pipeline is. So where we are as NADEL is that we recognized the importance of recognizing all the languages. Thank you.
Just to add to the political, at least as we appear to be moving from a political perspective, that can never be so, because when you develop any policy, you consider the past and the contribution of the past to where you are. Otherwise, then you are ignorant of why you should develop the policy. So in a discourse of this nature, there's no way that we can talk about the past. Unfortunately, at the heart of the past with which we're confronted is racism, unfortunately. And in one way or the other, we must confront those realities so that we don't go back to those realities. and we ensure that we don't bequeath to our children what our parents bequeathed to us. Number one. Number two, if we are happy with the foundational processes which seem to have commenced, and I'm yet to see my children learning in those languages. Maybe they're unfortunate. They will learn as they go on in their indigenous languages, but they are not one of those who are learning in indigenous languages. But if that process has commenced, what we are saying, and this is what NADEL has also said, let's wait for all languages to be developed. we're happy. There's a process, and let it be a process that benefits everyone else.
Okay.
And until
I
there's
think those points have been well made.
Yes.
Yes.
No. Just to wrap up. Just to wrap up, Chair. Until there's a curriculum that has been developed in the science of law, in specific languages which are indigenous to this continent, then and in that case, we shouldn't move away from where we are, and simply that, unfortunately, the English as language as we have it at this point should stand. Thank you so much.
All right, thank you very much. Mr. Lawrence, you will have an opportunity at the end to comment, not now. I've taken note of this letter that you've written to me, but you will get an opportunity, the last bite. Now I'm going to call upon the LPC to come forward and then make their presentation so that we can wrap up the proceedings of today.
Thank you, Chair. And with your permission, I noticed that your camera does turn. I'm going to ask permission to remain with my computer and my notes.
Okay.
That's a bit difficult.
No problem. The one thing that I want to mention is that because this is a summon, it would have to put you under oath if you don't mind.
It's fine.
Thank you very much. Do you swear that the evidence you are going to give in these summons proceedings is the truth, the whole truth, and nothing else but the truth?
I do.
If so, raise your hand and say, "So help me God."
So help me God.
Thank you very much. Please proceed.
So, thank you, Chair. I think let's, because I see the colleagues here have all attempted to be a bit floral in the submissions. And I think from that perspective...
Just please introduce yourself. Just please.
Oh, sorry. My apologies. It's Ignatius Briel. I'm Director of LPC Gauteng. I'm here with my colleagues. To the left there is Ms. Paul Arnold Nfusi. She's the Acting EO of LPC. Our colleague, Ms. Simone Magadi. Our colleague, Advocate Cornwall Chavungwa. Sorry, I always slaughter your surname. My colleague from Gauteng, Ms. Maud Ferreira. And my colleague, Brian Mhlongo. All right. So I think there's a lesson to be learned if we go to the Bible and we look at the story of the Tower of Babel. And what the Bible tells us is that the people congregated and they became clever, right? And they started building a grand city and they started building a tower. And they said, if we can do this, nothing can stop us. And God came down and God saw what they did. And God said, if they can do this, they are going to think that they can live without us, well, without me. I am going to disperse them. I'm going to make them speak in different tongues, to confuse them, to make sure that they cannot achieve what they have set out to achieve. Right. Now, I'm not saying any of us are God, because definitely we are not. But I think the very important lesson there, and taking it back to the Constitution of the Republic, the aim of the Constitution was to achieve reconciliation and nation building. That's one of the main aims. The foundation on which you build a nation and reconciliation is common understanding. And I think a lot of the speakers here today have already demonstrated that by using all the different languages, we are sometimes depriving ourselves of that common understanding. Now let me be clear, ek is Afrikaans, ek het op die platteland groot geword, ek is lief vir my taal. But I also need to be cognizant of the realities in this country. And with the greatest respect, Mr. Chair, and some of the colleagues here, I think it would be absolutely ignorant of us to ignore the political realities and history. Okay? We can never divorce in South Africa the history and the politics from language. Now, from that perspective, and just by way of opening the discussions, as an Afrikaans-speaking person, the very last thing I would want is for some policy to be developed in line with the complaint that says, bring back Afrikaans as an alternative exam medium. Because what's the inevitable outcome? We will once again be reinforcing the divisions between the population in the country. Because once again, you would have one indigenous language that's being elevated above the rest. I think where I do agree with the majority, or frankly all of the speakers here, is the absolute critical need for the development of all languages. And let's not get bogged down on whether the technical language exists. I think we can agree that a lot of the technical language doesn't exist. But that in itself is not the main hindrance. I think there are some further practicalities that we really need to take into account. So, if we look at Section 6 of the Constitution, it talks about the development of multilingualism in a manner that's fair and equitable and achievable and all the nice words that the Constitution uses. What the Constitution does not say is that there must be equal use of all languages. It says equitable. What the Constitution does not say is to implement all 11, 12 languages equally at whatever cost. It says to do that as far as it is practicable. Now, when one talks about your language, there's a reason why it's called your mother tongue, right? It's something that's very dear to people, and that's why it becomes very emotive if you start saying to people that we do not have the money to offer the exams or the training or whatever the case might be in all the official languages. It's very emotive, but the reality exists. And I think if Pansal has a look at the LPC website, you will notice that our financials are published. It's a matter of record. The LPC does not receive any funding whatsoever from government. We are entirely funded through practicing legal practitioners. One of the colleagues on the other side of the room earlier mentioned that we are one of the biggest bodies. We are by no means. Right, there's a lot of other bodies in this country that's way bigger. When it comes to being the prominent body in the legal fraternity, yes, perhaps we are afforded that right by virtue of the fact that we are the regulator mandated by legislation. But it does not mean that we've got the funds to do what needs to be done for the promotion of multilingualism. I think you would have seen in some of in the submission that we had provided to you, the tremendous running deficit that we've been operating with. We've also mentioned to you the figures around the cost of the exams. And again, I want to just backtrack a little bit and look at the objects of the LPC in terms of the Act, right? One of the objects is to promote access to the profession and to remove barriers to entry. So part of what the LPC does to do that, and by no means is it sufficient, and I don't think any of us would say it is, right? But within our means, what we do is to actually subsidize the exams. I have done a calculation at some point last year, and if we were to run the exams on a break-even point, we would have to, at the current system, right? We would have to charge each candidate round about 600 Rand per exam paper, which does not sound like a lot of money, I think, for most of us who sit in this room, because we are earning a salary. Candidate legal practitioners are not earning those salaries. For them, 500 Rand per paper would be a lot, right? We are offering the exams currently at 150 Rand per paper. So you can already see that there's a massive subsidization of the exams. And that is with the aim of promoting access to the profession. Okay. So if we look at the complaint, and I will ask my colleague, Advocate Chavungwa, to also address you once I'm done here. But I do think it's pertinent for us to mention that the LPC is very much uncomfortable with the process that is being undertaken. And I think with right. If we look at the wording of the subpoena that was provided to us, if we look at the timing of this hearing, if we look at some of the comments even that have been raised right at the opening of this hearing, one cannot help but wonder whether a decision has not already been made within PANSALP of where this is headed. Right. I mean, we've been explicitly told that we will take legal steps. So one has to question what's the purpose of the hearing. Be that as it may, and as I indicated, Advocate Chavungwa will address you on that aspect. But let's, for the sake of cooperation, talk about the merits of the complaint. So if we look at the history of the language policy, I think we are all at IDEM that initially there was a misstep in 2019 when we had published a notice to say that the exams will only be offered in English. The LPC was called out on that, and we listened and we retracted. Following that, in 2020, we published for comment the proposed language policy. Now, interestingly enough, and I think it's common cause that the complainant himself also made comments to the proposed language policy. And the comments made there are substantially similar to the complaint that has been raised. So after we had published for comments and we had received the comments, obviously the comments were considered by the council at that stage, keeping in mind that the council of the LPC alternates every 3 years. So the council back then had considered, and after consideration, the policy was then adopted by the LPC in 2020. Now there's a hiatus between 2020 and 2023, during which time the use of Afrikaans still continued for a period. And it's basically relating to the transition that happened within LPC, right? At some point, the decision was made that the exams need to be taken over and run from within the LPC, right? Before 2024, the exams were actually administered by the Law Society of South Africa. Okay. So the exams from 2024 was done by LPC directly. It was no longer outsourced. Yes. Yeah, from 2024 March. Now, talking about the outsourcing, I think a very important point that needs to be made, and I think one of the speakers earlier mentioned that the LPC needs to offer the training in the different languages. The reality of the matter is the LPC does not offer the training. The training is offered by various independent bodies, accredited by the LPC, fair enough, but bodies like the BLA, NADEL offer training. There are independent service providers who offer training. Okay, so the LPC itself does not offer training. But coming back to the issue of the consultation, because I think, let me just close that argument. I think a very important argument to be made. When there is a requirement for consultation, for example, on the policy, and I mean, you can look at the case law. Consultation does not mean consent. It does not mean consensus. It requires the acceptance of comments that are made and the legitimate consideration of those comments. And I submit that that has been done. Now, if we need to look at the reasonableness of this policy, I think a very important point that needs to be made. By no means does this policy prohibit the use of Afrikaans or any other language. This policy does not change what the Constitution provides for in terms of the official languages of the country. What this policy does is it prescribes, within the context of the LPC situation, meaning our financials, our resources, what it is that the LPC can do. The policy simply determines the language of record of the LPC operations and examinations. And I think one of the earlier speakers also spoke about that. There's a difference between a language of record and an official language. And for that purpose, I want to come back to where I started with the Tower of Babel, right? In my office in Gauteng, I have 150 employees roughly. There's probably 10 Afrikaans-speaking employees. Majority speak one of the Tswana languages, Sotho languages. Very few Zulu, but they are there. And I can promise you that it's going to be very difficult if we allow employees to each use all of the languages in official communication, because our work will come to an end. On a practical level, they are engaging with their own languages. But for record and for official purposes, outside communication, the preferred language is English. And I think where this also becomes relevant is in the context of the wider legal profession. The reality of the matter is that the courts have adopted an English language policy. And I take note of what's been said in the complaint to indicate that this is an unconstitutional decision by the courts. The concern I have is whether we are not attacking the wrong target. Should the starting point not be the judiciary? Should the starting point not be the Chief Justice to say, look, your policy that you've implemented is unconstitutional, fix this? The LPC has no ability to amend the language policy of the court. We don't have a mandate to do that. So whether the LPC adopts Afrikaans or isiZulu or whichever other language, it is not going to change the policy of the court. Now, to say that we do not want to attack the Chief Justice and litigate against the Chief Justice is not a ground to then take it to the LPC and make them responsible for that decision. And if I may be allowed to very briefly, and I'm not going to take too much on that, I'm looking at data from the Pretoria High Court. Now keep in mind, the High Courts especially are under extreme pressure with the volume of work that they are dealing with and the number of judges who are available. I think anybody here who deals with the courts on a regular basis would know the extent to which the courts have to resort to acting judges who work on a pro bono basis to try and deal with the volume of work. Now, if we look at the lead times, so this is the time that it takes somebody to get to court, to have their matter heard. Full court civil appeals, 2 years. Magistrates Court civil appeals, 1 to 2 terms from date of application. Family court matters, 4 weeks. Opposed divorces, 2 to 3 terms. Long duration trials, 6 months. Opposed motions, 12 weeks. So remember, when somebody goes to court, they've got in their view, a legitimate dispute that needs resolution, and most people want resolution urgently. Now, if we look at these lead times, these are already untenable for the majority of the public. My submission is, if we have to enforce on the courts a process where judges have to be allocated for specific languages, it is going to exacerbate these lead times. It is going to exacerbate the lead times if practitioners would be forced to allow for interpreting services, which, by the way, is something that's quite problematic as well in the courts. At the most recent meeting, the JP indicated that they've got tremendous challenges with availability of interpreters in the courts. So again, I'm saying to bark up LPC's tree is probably the wrong tree. I think there are much bigger systemic issues that we do need to address. And I'm glad to hear what you're mentioning about the development. But I think one of the colleagues also mentioned it needs to start from grassroots. It needs to start from primary school. Bring back the ability of children to be taught in their mother tongue. And that has not been there for many years. Now, if we look at the decision of the LPC, so I've already mentioned to you the financial situation of the LPC, which is simply prohibitive for the LPC to try and implement what the complainant wants. I mean, a very simple argument would be the practice had been that the Afrikaans and English versions were printed on the back and front of the question paper. Now, automatically, you had double the printing. Unfortunately, I've heard the argument to say that let's ask the candidates up front, well in advance, which language they would prefer. It is a possibility. At this stage, the LPC systems do not have automatic or system-based registration processes. Okay? It's still very much paper-based. The LPC systems require a lot of development to get up to track with where we need to be. The other difficulty is the number of candidates who actually register for the exams and then simply do not arrive to write. And this can be as high as 40% of candidates who do not pitch to write the exams. Now, if you have to prepare special papers to deal with that, and these candidates do not arrive, it's a further wasted cost. Then it is the cost of getting examiners to draft the papers and translate them into the different languages. Because these papers we have to pay for the drafting. It's not drafted in-house. We get examiners that we then get to draft the paper under our auspices. Examiners also need to be appointed to mark. So again, let's use Gauteng as an example. We use approximately 24 examiners per paper. You're looking at per paper between, in Gauteng, 3,000 to 4,000 papers, right? Now, to get legal practitioners who's not had the benefit, like Prof. Sorry, I'm going to butcher your name. I'm not going to try. Who's not had the benefit to study in their mother tongue. Because let's face it, majority of the current practitioners out there either studied in Afrikaans or English. Who are you going to get to come and mark those papers in the other indigenous languages? They've not been trained in those languages. So I do think the argument still holds to say you don't start building a house from the roof. You start with a foundation, and it can never be the other way around. The last item that I would like to address is simply on the issue of the use of AI. Yes, sir.
Just before we move from that point, there's a point that Prof. Luzalo raised about a learner who would have learned everything in Afrikaans. What do you say to that learner who now has to write in English, given the rights that are promised in the Constitution?
So I studied in Afrikaans, and I wrote in English. Yes, I do not believe that we should diminish their rights. But if we need to be honest, I think majority of Afrikaans-speaking students would be fairly conversant in English. Also keeping in mind, again, talking about the foundation and the roof. Majority of case law at the moment that students study is in English. So whether you are Afrikaans or not, or even study in Afrikaans, the case law that you're going to read is in English. Okay. Okay, sorry, I wanted to address the point of the AI. I think that is a very useful tool, but at this stage, it's a very dangerous tool. And regrettably, so Ms. Ferreira next to me is the head of department for professional affairs. So she deals with the admissions of candidate attorneys. She also deals with administering the exam. The number of candidates that come across our desks who have a disciplinary record for plagiarism and irregular use of AI is staggering. And those candidates are inevitably delayed in their admission process because it's a very rigorous test that they need to go through in front of the Professional Affairs Committee of Council before they can be admitted. Because plagiarism and slavish use of AI could indicate that you are not a fit and proper person. So that's from the legal practice perspective. But I mean, if you also look at some of the recent case law, where practitioners have been found wanting because they used AI and quoted nonsense, right? You even had within government somebody who used AI to draft an AI policy and didn't bother to read it properly. So it's a useful tool, but we need to be very careful. One cannot simply say that AI is going to do this for us. I don't know if AI has the ability to do a translation of a technical exam paper into Chivenda. And a memo, for that matter. Chair, I think I'm going to close my submissions there. Then I will ask my colleague to address you on some of the technical aspects.
Just before you step off, you mentioned the point that it appears that PenSALP has already made a decision with regard to this particular matter. And I want to clarify that this matter has been elevated to the board, and we are a committee of the board. Management would have done their own work, but this proposed really is to get more information, and then we're going to take all information and give it to the board will make a decision. There may be things written there that are unfortunate, but the board has not yet made a decision, and they've not really considered all the information that has been put here. Thank you. Yes.
May I proceed?
You have 10 minutes.
Only.
Okay, how much you want? 20 minutes.
Yeah, let's work on 20.
Yes, that's fine. Let's proceed.
Okay, thank you. Thank you for allowing us to come before you, even as we come crying that you have already decided the matter before we even came here. You will have realized from our submission that those are the first points that we take, basically deconstructing your subpoena, because the language that you're using in your subpoena gives one the impression that this for us is just going through the motions and nothing else. And if it were a question of us going through the motions, why are we here? And that is a big challenge. What buttresses this notion is the fact that Dr. Sishoka, Dr. Sishoka, she was the second person to make presentation, and what is billed as a supplementary complaint. However, in the presentation that was made, it became categorically clear that a decision has been made, and we were being presented with recommendations. We're sitting here, we have not yet made any submission. We have not contributed anything. And before we even start opening our mouth, we're being presented with recommendation on an investigation that is in medias. That becomes a serious problem. So to tell us as lawyers, in as much as you told us that we should disrobe ourselves as we come here, because we are not coming here to litigate, and it is a very difficult thing to tell a lawyer not to become a lawyer. So when we arrived here, we decided, let us listen to everything that is going to be presented and then take it from there. But be that as it may, if I may just delve into some of the issues, I'll start by disabusing some of two issues that were raised earlier on. Language. This matter is primarily about language, and nothing else. So language is a primary vehicle for human identity, shaping how individuals perceive themselves and connect to the world. It is not merely a tool of communication. It is a fabric of culture, thought, and personal expression. Language and politics are one thing. You cannot divorce language from politics. They are both intertwined. Words are rarely neutral. They shape reality. They establish power dynamics. They define groups and enforce ideologies. So when a person sits and say, no, but I mean, we cannot be sitting here and debating politics when we are talking about language, I get baffled as to what is the reason why we are here. We are here to discuss an issue of language because somebody felt that his language rights are violated. And that violation and that right is founded on the Constitution. The reason why the Constitution decided to protect language, it was because of politics of language. So every linguistic choice, from dictation to translation to policy, it reflects society's power structures. So we have two languages in South Africa. That is English and Afrikaans. Those are the only two developed languages that we have that are rich than any indigenous language that we use. I'm glad actually my other colleagues have spoken on this issue earlier on. As we're sitting here, we're debating an issue about Afrikaans, but we're speaking in English. You are PanSlab, supposed to be promoting 11, 12 official languages. You get a complaint about the suppression of Afrikaans, and the first correspondence that you direct to the respondent, at least not in Afrikaans, is in English. Is that by accident? No. There is a reason. Because English is a language of convenience. I had Professor, you will forgive me for colliding. Oh no, I'm not gonna try because I don't think. Yeah, Dr. Khala. Okay. It's not by accident. And we have the complainant himself, who is presenting a complaint about the suppression of language rights in Afrikaans, but he comes and presents that in English. Doesn't that buttress the very reason why the LPC adopted this policy? Can the LPC be faulted for having adopted the language policy of record being English? It makes no sense that we'll sit here and be talking about a language that should be protected, but we are not protecting it ourselves. It makes no sense that on the 13th of December, 2023, the LPC published a notice informing the public and everybody else that is interested in writing exams, competency-based exams, that the exams are going to be presented in English language only. PanSlab immediately reacts to that. Not immediately, because I heard Mr. Lawrence say the notice was issued when every lawyer was on holiday, because that is the time when lawyers go on holiday from the 13th and the 15th of December. And but immediately after New Year, LPC receives a letter from PanSlab. That letter is giving some form of directives to the LPC. Paragraph 6 of that letter is very telling. So you read the policy, and then you send a letter, and it's like a cease and desist letter. Withdraw this policy. Present us with a plan within 12 months. Why is that significant? The significance of this issue that I'm saying now is founded on the basis that you participated in the public comment process. On the 14th of August, 2020, the LPC issues its draft language policy, inviting comments with a closing date of the 14th of September. Mr. Lawrence and PanSlab and a number of organizations submitted their comments to the LPC. The LPC sits and considers all this and comes back with its policy, does not implement the policy. The policy was adopted on the 20th of November of 2020. It is not implemented immediately. And only on the 13th of December 2023, the LPC issues is notice. It's not as if PenSlab was not aware of this policy. It participated in the public participation process that the LPC initiated. It is not as if Mr. Lawrence was not part and parcel of this, he was not aware of this. So registering a complaint against the LPC in such circumstances is as if the parties that are writing to the LPC are oblivious of the participation that they were themselves party to. It is as if the LPC started something new that nobody was aware of. I was glad, at least when you were asking Mr. Lawrence earlier on when he was making a presentation, as to whether he did not participate in the comments that were requested by the LPC at the time, and which he answered in the affirmative that he did. So if your comments are not accepted, or they do not sway the respondent, being the LPC, then they morph into a complaint. On what legal basis does the rejection of a comment become a basis of a complaint? If you are saying that your comments were not accepted and you are not happy about the fact that your comments were not accepted, what is your next recourse? Is that not to review the decision itself instead of lodging a complaint? This is where we are sitting. A letter was written to the LPC. The LPC responds on the 1st of March on 2024. 2024 March up to 5 May 2026. Tubestel. Silence. Nothing is heard from PenSlab. What comes next is a subpoena. A shocking subpoena. Because now we are surprised. Who has complained? And about what? In the subpoena, then we are informed about a complaint of Mr. Lawrence that was made on the 16th of January, and we're only being made aware of the complaint on the 5th of May in 2026. Why? There is no explanation of this hiatus. The LPC policy is in implementation for 28 months. To the extent that Mr. Lawrence had recourse to review and set aside the LPC policy, that opportunity is gone. He had that opportunity from the date of issuance of the notice, and to do so within 180 days. PenSlab is sitting on his complaint. PenSlab does not do anything about his complaint. We do not see any report from PenSlab about Mr. Lawrence's complaint, even when legislation says you need to make reports on a quarterly basis about complaints, or even a shorter period. So a complaint that was lodged on the 16th of January in 2024 only gets oxygen on the 5th of May in 2026. That is, I have to say with due respect, some serious dereliction of duty. And that is probably what should be investigated. Let's get to the substance of the complaint. If you look at what the complaint is all about, as Mr. Briel has already said, it's a mirror image of the comments that were already submitted to the LPC, considered, and did not hold sway. The LPC gives a very succinct response to your letter of the 11th of January 2024. You do not engage with any of these issues at all. You don't come back to the LPC. The only time that you decide to engage with this is in the subpoena. How is that feasible? That becomes a very problematic situation. And it puts us in a very serious predicament as the LPC. When we interrogate these proceedings, what they are really intended to achieve. In your annual report of 2024-2025, what is interesting is that you mentioned this complaint. No, 2024-2025. You'll see that in our submission. We have quoted that part of your report verbatim. You mentioned this complaint. And what you mentioned in the report is that it's actually a decision. If you look at it, I'll have to go to it to be fair to yourselves. Okay. It says on firstly, it's on paragraph 55 for my submissions then. Firstly, it doesn't represent the LPC position correctly. It says that the essence of the complaint was that the LPC's language policy, which has adopted English as its only official language, there is no such policy at the LPC. The LPC policy is very clear. It has adopted English as its language of record, not official policy. And unfortunately, this is being presented in an annual report, which is being read by members of the public. And they're getting certain things wrong, and as if the LPC is contravening the Constitution. And you say that certainly its current language policy contradicts these objectives, particularly by failing and or neglecting to promote multilingualism and the development and use of previously marginalized languages per the Constitution. PenSlab is pursuing this matter further with the respondent and believes that it may still be resolved amicably as provided for in the enabling legislative framework.
Let me just interject you, Council. I want you to decode this language of record and official language.
Mhm.
What exactly do you mean? Are you suggesting that reports are written in any language, complaints are processed in any language? The issue of the language of record is only for the purposes of the examination, or does it include even handling of complaints, proceedings that are brought before the LPC? Maybe help us understand that part.
I'll assist you if you can allow me to finish.
I'm going to allow you to finish, but I want to capture this point.
The language of record. Okay, let me give you the following scenario. Maybe at least if I explain it in this way, you'll understand. The United Nations actually has got hundreds of languages. All right. It has got 6 official languages of record. It doesn't have an official language. It has got 6 official languages of record. When you have got a language of record, it means you are not disregarding other languages. And that is what the LPC policy, if you read it properly and in context, and what it provides, it does not say we are going to use English exclusively. It says we are still going to utilize the other official languages. And our utilization of these official languages will depend actually on the area where that language is used. In a particular province, actually in Limpopo, you will have, I'm Venda, sorry. So in Limpopo, you will have Venda, you will have Tsonga, you will have Pedi, and then you will have African-speaking people, you have got English-speaking people.
Yeah, let me interject you. Now, LPC's got various statutory mandates. I want you to be very practical with me. Now, of all these mandates that you have, language of record, does it mean that in terms of executing those mandates, only English is going to be used?
Yeah.
Is that what you suggested?
So basically, what the records of the LPC will be in English. However, you are going to utilize any other official language, but in order to record any communication, external and inside, it will be in English. That is what language of record means.
If I lodge a complaint in isiXhosa,
yes,
will you then translate it to English so that you keep it for your records purpose? Is that what you're suggesting?
It will be dealt with by someone who can speak Xhosa and records what the complaint entails in English, and then it will be responded to you as a Xhosa person in your language.
Thank you. Interjecting, I wanted clarity.
So I think now you took me out of my train of thought.
Apologies. Apologies.
So, and you also stole my time. But in any event, so the point that I was making is, if you look at our letter of the 11th, sorry, or the 1st of March, we succinctly deal with the issues that you raised in your letter of the 11th of January. And in dealing with those issues, we're saying whatever it is that you may be raising right now, after consideration of what we did and the decision that we came to in adopting this language policy, is a question of reasonableness. And that issue of reasonableness actually does not require investigation. It does not require the PENSLAB to invoke the powers in section 11(4)(b). is a different leg. LPC has passed the Paja test of adopting a process, an administrative process that is transparent, fair, and lawful and just. By inviting consultation process, inviting all interested parties to participate in the comment process on the draft policy that closed, considered, adopted, and any aggrieved party has a right to judicial review if they are aggrieved with that process. Otherwise, then we will sit here and conduct some pseudo review process of the LPC process of adopting its language policy. It again points to the fact that the complainant and Penslab participated in that process. So they can't be complaining about something that was submitted to LPC, considered by the LPC. Yes, they may be aggrieved. That is natural. When something that you said and you wanted to sway someone was not accepted by that particular party, you'll be disappointed. But that disappointment does not warrant this process. And with the greatest of respect, I dare submit that this process is illegitimate, taking into account the circumstances under which this language policy was adopted. And in dealing with the issue of reasonableness, in paragraph 62 of our submissions, we highlight the following issue: that a language policy implemented within a multilingual and multicultural setting must pass the reasonable practicability test. Such a test includes, but is not limited to, the following. I'll just deal with the heading. You can deal with the other issues that we have raised in there. Is the historical redress and equity. The question to be asked is whether the language policy actively accounts for the historical imbalances and marginalization of indigenous languages. And the answer with regard to this policy is that it does. Yes, you may criticize it. Your criticism does not mean that it does not engage with them, because it does so in succinct terms. We say the language, I mean, the legal profession itself is a multilingual enterprise. They've got people from all walks of life, actually, who went to school, decided to be lawyers. Some come from El Dorado Park, some come from Soweto, some come from Bukokwa, some come from Venda, where I come from. So, and this is a group which is rich in diversity, and that deals with people rich in diversity every day. That brings me to this concept of multilingualism. You know, the idealism of multilingualism.
Are you summing up the key points? I think your
no,
time is.
My time is
very
gone.
fast.
Okay, let me go back to the key point. The second key point is demand and viability. The question is whether the LPC has sufficient number of candidate legal practitioners requesting Afrikaans to justify the administrative and financial expense to be invested in promoting this. And we give the figures there that between 2021 and 2023, at least 26 candidates wrote exams in Afrikaans at any sitting in which 4,912 and to 7,898 candidates sat for exams. So you look at that from the prism of the expense and the kind of investment that you're going to make there. And then we refer to the judgment in AfriForum and another versus the University of Free State, 2018 2 SA 185 CC, that deals with that specific issue. And then the third thing is the resource availability. The LPC is not a public educational institution envisaged in Section 29(2) of the Constitution. The LPC is a regulatory body whose primary mandate is to regulate the legal profession. Although involved in overseeing legal education and administering admission examination, it remains a regulatory body and not a school or university or learning center. The fourth item that deals with infrastructure and operations. The LPC is a subscription-funded organization. Its revenue is chiefly derived from the annual levies paid by the legal practitioners and payment from legal practitioners as a fidelity fund, as well as a bid coming from exams and admission fees. The LPC financial statements of 2024 recorded the total annual revenue as 299,997,790 rand, with a running deficit of 122,295,211. The exam fees made up about 8,062,741 of the revenue. The assessment and exam fees expenses as recorded is recorded as 13 million. That's almost double. So it stands to reason that the exam fees paid by candidate legal practitioners are insufficient to fund the amounts that administration, assessment, and management of exams require. Yes, it has been said by previous speakers that the idea that the rights should wait for money in order to be realized is not conducive. Yes, it may not be, but we live in a real world. All these things that need to be implemented, they require money. In order to employ somebody who's supposed to be a language practitioner, to go and sit at the LPC only to look at complaints, they require money. So if you at least utilize the resources that you have within the LPC of functionaries within your establishment who can also work as language competency practitioners instead of their interpreters solely employed to interpret documents. They can at least be photocopying there, then they can also be sweeping there, or they can also be doing some other administration. And when there are complaints, then you sit with a complainant and say, oh, no, there's a vendor person here who cannot communicate with, and then they call that particular person to assist. And that also fosters intercultural connectivity. I don't want to deal with the complaint of Mr. Lawrence because I feel that it has been answered properly. And in any event, with the posture that I have already said you have taken which I'm not inclined to believe that it has changed. I would not want to even get there. So
Okay.
I think that will conclude my submissions, and our view is that yes, should there be consultation about upliftment of other indigenous languages? Indeed, 100%. We are all for that. I don't think nobody is differing with that.
Just tell me
what-
before you step off
Yeah.
the floor. At what point do you capture language preference? Is it at the registration of these candidates or at the examination point?
At what stage do we?
At what point do you capture language preference?
There's no language preference capturing.
So, okay, all right.
But that question, if it is like deconstructed, will that not negate the very policy that we adopted?
No, I wanted just for clarity purposes.
Yes.
I hear what you're saying. I've heard your point of view.
Yes.
So thank you very much for the presentation. And I think we want to appreciate the posture that you've taken. You have given us a lot of information that we'll sit and consider. I'm now going to allow the committee members to comment or any questions of clarity to both your presentations. I'm going to take.
I always wanted to use my powers. I'm looking at the time, and when we started, sorry, Chairperson, I'm the chairs of chairs. When we started here, I did indicate that we will listen to the complainant, and then we will listen to yourselves, and then we have done exactly that. But in between, we had our presentations. So looking at the time now, I'm tempted to say that we have listened. And I'm worried that if we say the other chair, the junior chair, if I may use the word with due respect, we allow the questions. We book this room up until a particular time, and also as according to our agenda. However, as I'm also human, you read the mood in the room. If there are really pressing questions, I would say probably I will allow the chair to take probably 1 or 2 comments. And please don't abuse that, because if you do that, as the chairs of chairs, I won't sit, I will stand up and say that in conclusion, and then I will close this session, because unfortunately we also have the people that are in the virtual space. As much as we would like to proceed, but unfortunately, I think what we said we'll do, I think we have achieved that. But if there are pressing questions for clarity or any comment, maybe 1 or 2, let me then say that, let me allow that. But if there's let's see first before I can say yes or no. How many people would want to really say something? Okay, from the board. Okay. These are the only people then from the board. Well then, Chair, let me hand over to you, and then that will allow you. But should anything emanate based on what they have said, then as the chairperson, then I will have to close this meeting. I think.
No problem,
sorry,
Chair.
but also the clarity that you said that you're going to give Mr. Lawrence
I think we've heard him.
Yeah,
I
we've
think
heard
he had
him.
enough time, an hour to present.
It's a presentation. Okay. So it's only the 3 hands we all agree?
And I think, Chair, we can
Okay,
even
sure.
allow written submissions after here. So
Yeah,
I don't think it's a problem.
absolutely.
Let the committee members have the last bite, and then from there we can wrap up. I can give it to you, Chair.
Yeah.
Yes.
No, thank you very much, Chair. Let me start by appreciating the sound presentation that we have received from LPC. I should say, to be frank, You indicate that PenSalp, by the way, it's PenSalp, not PenSalp, or PenSlab, just to correct that. You indicate that there's a decision that has been taken, or a position that has been taken, and the chair of these proceedings had tried to clarify that as the board, the reason why we are here is so that we can receive the information that will inform the board on going forward. I should say, from your sound submission, you know, when the presentation are made from the beginning, the mind moves with the information that comes, and from the presentation that we made, we are convinced that we have received information that is required to assist us going forward, and we did not come as the board. We did not come with any position that we have taken. I think you've given us information that some of us we would have missed, because by the time when this matter started, we were not members of the board. So some of the information that we presented is going to really assist us in going forward. I hope that by the end of this, when you go back, you also move from that mindset to say that we came with a position that we've already taken, because that is not the case. Just to touch on the question that advocate here has mentioned, you have indicated that there were about 26, is it 26 or 28 out of 4,000 that took 26 wrote the exam in Afrikaans. So I wanted to understand that before this decision to have the English as the language of record and the examination being done in English only, how did you determine the choice of language of examination? Does it happen during the day of examination, or I think that was the question that was being asked, or upon the application, then there's a choice to say, I want to do my examination in Afrikaans or in English, and was the choice made for only those two languages? I think that is the clarity that I would need. But also to then say that there was also a call for a round table. I think it would assist to have a discussion with institutions of higher learning, because I know that these institutions have started to have terminology lists developed in different fields. So that process can also assist, and when practitioners like yourselves participate in those academic processes, it will also assist the development of indigenous languages, because you have the practical experience. Academics have that theoretical and academic experience, and working together can assist in the development of these languages. But I should appreciate, as I wrap up, Chair, when with the presentations that we received before you came in, I anticipated a very defensive and practical, confrontational submission from your side. But I should say, if I was angry, you were able to calm me, and I was able to hear the soundness of the decision that was made based on the approach that you took, different from the previous presentations that were made. So I appreciate the submission that we've made. Thank you very much.
Thank you very much, Mr. Chair. I must say that today's deliberation was very, very educational, very informative. We've learned a lot. I think we were discussing today during tea that it is so sound. You know, we've listened to both sides and we've come to a great understanding of the pressing need about multilingualism and so on. And I would like to hasten to add Professor Kalakala, right? Chairperson, I tend to agree with Professor Kalakala's observation regarding the disconnect between PANCELP and the CRL Rights Commission. In my view, language, culture, and religion are not standalone concepts, but are deeply interconnected aspects of identity and human dignity. As someone who serves in both institutions, I believe there is enormous potential for greater collaboration, particularly in research, advocacy, community engagement, and social cohesion programs. At a time when resources are limited, like you mentioned, we should be looking for opportunities to work together rather than operating in institutional silos. A stronger relationship between PANCELP and the CRL Rights Commission and organizations like yours will undoubtedly enhance the impact of all our institutions and better serve the people of South Africa. So I'm very supportive of that roundtable discussion, right? So that we can take this forward without trying to fight each other. Thank you very much.
Thank you, Doc.
Okay, thank you so much. And thank you so much for the presentation. I think from my end, it became quite clear in terms of the position that you took in terms of the language policy. But I do agree with my colleagues over here. As reading the environment, what also becomes clear is the issue of language development, that we need to develop language. I'm also taken aback in the early 2000s when I used to be in the auditioning and the modeling sector, whereby you stand in front of the panel and you need to introduce yourself. There was a young girl there whom wanted to introduce herself in Afrikaans in the early 2000s. Unfortunately, the panel did clearly indicate that no, the language that we are going to use is English and not Afrikaans. And unfortunately, due to the language usage at that particular time, which was only Afrikaans, she was disadvantaged. Well, for some of us, it became as an advantage. And having to listen to this presentation, I think my clarity-seeking question, or just an emphasis from LPC, would say that in an event where anyone will then want to use Afrikaans as the language because they feel marginalized and excluded, what are some of the mitigating ways or provisions that you could implement to see to it that they do not feel unfairly treated? And I will also go back to the submission, your submission, where it states that over the period from March 2021 to August 2023, no more than 26 candidates wrote the examinations in Afrikaans at any sitting. And I think the DC did mention that. But mine is to look into the demography of the individual or the areas, if you do have in record, to indicate no more than 26 candidates wrote the examination. Do you perhaps have that kind of a provincial or table or graph that indicates maybe where these particular candidates might be located at? But what I also find interesting, and maybe also putting this on record and getting clarity from yourself, is the issue that not a single candidate, legal practitioner, raised an objection to this. So I just want this to be put on record, that I clearly understand that it still stands that not even one candidate, legal practitioner, raised an objection to this. With that being said, Chair, I think this engagement has been very much fruitful. We will go back to the drawing table and see what we could work moving forward. I thank you.
Oh, okay. Because it was a question, would you want to respond before I do the closing remarks? Or do you want your closing remarks?
Thank you, Chair. I think, let me just respond on the question of how the previously, because if I understood your question correctly before, there was no determination beforehand. It was simply a question of the paper was printed up front and back, front being English and back Afrikaans. So the candidates could decide on the day. On the other question of what we can do if somebody requests, I think that's something that we would need to go and consider. We're not going to give an answer to that now, unfortunately. Okay.
Well then, colleagues, and let me start and thank the chairperson for conducting this hearing and assisting us in this regard. And let me just indicate that all of us, my colleagues and also other people, with the questions, my closing remarks were taken by my colleagues and also, and other people. NgesiZulu ngithi njengoba sebashilo elami lelo, and then let's go home. But let me just maybe, I think from my side, the main take home here is that as we indicated when we start, is that we'll listen to both the parties, and indeed we have done that. And that maybe just clarify 1, 2 or 3 things in that regard. That we indeed, all of us, including myself, are enlightened. Not being a politician, but as a language person. But maybe it will be a debate for another day, combining language and politics, because I'm a linguist, I'm a language person, I'm not a politician. I make that clear distinction when I stand in front of the students. I don't do politics, I do language, but that's the discussion for the other day. But I am educated myself, and I'm very appreciative of that. And then in terms of clarifying maybe some of the things, I think from my side, what I've gained from this exercise, especially coming from your side, is that the distinction making the language of record and the official language and language policy. I think for us, probably, not even myself, it was blurry. I tended to take, to combine both. But you have clearly articulated that there's a distinction between the language of record and the official language, and, and all the other things. And also you are embracing the development of other official languages. And for me, that is really comforting from my side. And I think I would like to believe that from the board members, that, I came in here thinking, combining the two. But thank you for educating us in that regard. That is appreciated. And then in terms of the clarity from the other board, from us as the board, is that I'm not sure, or the other issues have been taken care of in terms of the terminology development and other processes, is that Pensel, there was no board, there was a void, there was a full year where the minister and parliament did not appoint the board. And some of the stats and the discussions and the statements that are there are included. It was done by the CEO at the time, in the absence of the board. This board only started in March 2025. So there was the whole year where there was no board. So hence there might have been some time lapses and so on. As a result, that had a knock-on effect in terms of these proceedings. That's why now. Why now? Because there is a board, for starters. It couldn't have been the office. And now, making that two distinction, the person who was presenting the CEO, although by default as the ex-official member, because she is the person who is in the, not ex-official, because she is in the entity, she is by default, she is the member of the board. But however, whatever she was presenting there, as my colleagues indicated, that was not the position of the board at all. That was the position of the office. So we as the board, as I indicated earlier on, is that the people that you see here, the 7 of us, we are 11, about 10, 11 of us in full, and with different, roles. So we must then take this, the 7 of us, as this board, present it to the board. We've listened to the complainant, we've listened to this, we'll consolidate, then table it to the board, and then take that. So there was no predetermined idea and so on. So whatever was being said there. So unfortunately, because we always say pencil, yes, we are the board of pencil, but unfortunately also there is the office, the entity itself. So definitely whatever the views that were presented, that was the views of Ilokunjani or pencil. And I thought I wanted, and let me just maybe clarify that, so that we as the board, this current board at least, because there was the previous board, unfortunately for me, with my other fellow board member, I'm the returning soldier. But out of the 11 of us, only 2 of us were in the previous board. Then there was no board for the whole year, and all the other members that are here are in this new board. So when there was that communication and the writing to LPC and not writing and so on, there was no board. We did not exist. So hence probably that may be the delay and so on. But we are enlightened as this board. And let me not cite some of the things that are already then indicated. And I'm grateful that we were able to educate and enlighten each other. I think also the people that are in the virtual space are educated themselves, because we may assume certain things and move from a naive perspective, including myself included, that some of the things are being ironed out. But I'd like to believe that once we have consolidated and we're done with this process, then the communication will not only end between the complainant and the respondent. So it will also be taken to the members of the public, because it is of public interest. So we will definitely then do that. And then in closing, then let me just take this opportunity and say that thanks to all of you, thanks to the complainant, although he has left, and thanks to yourselves as the people who were then responding, and also for enlightening us. Let me also thank all the presentations, Prof. Khala, Nadel, PLA, who else, and the BSFA, and thank you so much. And let me also thank the staff, the team, the staff from PenSouth, accompanied by accompanying the CEO, and also the manager for linguistic human rights, and all the by staff. PenSouth is in 9 provinces. I'm not sure if you are aware of that. PenSouth is in 9 offices. So, and we also have senior provincial managers. Some of them are here. So let me take this opportunity and thank all of them. The head office of PenSouth, however, is in Pretoria, but PenSouth is in all 9 provinces. And then some of the staff that you see here, that is behind me and a little bit across, from the other provinces. Let me also thank the technical support. And let me thank the people that assisted us with all the technology and everything. And thank my deputy chair, 2000. Normally I say that he needs to do the closing remarks, but I thought it is befitting that, because this is a public hearing, I will not give him that opportunity. I started this, I must then finish it, but I do appreciate that. And then let me also then thank the chair for the session. And we did that. We really did a wonderful job, and I would like to believe, and also then say that we as a PenSouth, the board, wherever we have inconvenienced anybody, wherever we have wronged anybody, and let me, on behalf of PenSouth, on behalf of the board, let me take this opportunity and apologize. Sometimes when somebody says something, it's human to say, to react. And let me just say, I wish to apologize, on behalf of everybody. It was not intentional. We are all being human. And I wish to thank all of you for the participation and especially enlightening us. So this is it is already indicated that there's other submissions. May we can still then take them, but we will go back, consolidate, and then we will deal with that. Okay. Oh, okay. I'm reminded here that the written submissions, if people want to then do the written submissions, that should be done within the 7 working days. So then post that, then we will have to then consolidate and conclude. If it is beyond that, then probably it will be during the next financial year. But it is our request that we at least receive those written submissions. And then with that, let me wish you safe travels. I'm not sure whether lunch is still there. I'm not looking at the back. I'm even embarrassed because the time, the lunch time and so on, and the flights and so on. But the other logistics, other people will sort it out. And let me thank the office for all the logistics and thank Southern Sun for us. Thank you. This session is now officially adjourned and safe travels.